You guys should have got redirected over here. 10-minute warning? It didn't work. Shoot, did it not work? The redirecting? Dang it. Hold on a second. I had it. I know I did. Hopefully Ooh, I can't look anymore. Did it get redirected? Oh, shoot. Huh. Let me tell them. You did? Oh. K and B, you got redirected? See, I wasn't sure how quick. Put everybody that got teleported, let me know. I want to know. Did anybody get teleported? Because it looks like somebody did. K and B said it. Oh, that's my mom. Peep did. So I guess some people did. See, I was wondering because this time I started the live before I started it like a minute before the last one ended. So I wonder because the last time I'm like, should I do it quick? I thought like when I waited before that was worse because I didn't want people waiting. So maybe when I start it before the one lives, you guys see the notification. So people that clicked on the notification, if you would have just waited in there, you probably would have. Yeah, I think that's what happens. You guys didn't wait till this one officially ended. You saw the thing pop up live and you clicked on it before the other one redirected you. That's what happened, I bet. Because it looks like other people are getting redirected, right? Okay, cool. I was hoping because I wanted to, because I didn't tell many people. I just like did a couple messages because I was like, I'll just everybody will be redirected. So I didn't make sure I really told people too many people. You know what I'm saying? I think I wrote one or two messages. So um cool. Anyway, hey guys. So new documents came out for the appeal. So it does make me feel better that that his move had nothing to do with him being off death row onto like his appeal being which I knew because I knew there'd be court hearings and stuff. But I mean, some people I think were still wondering, why did he get transferred to a non-death row facility? It must be something else. I did see that one creator talking about like maybe he swallowed batteries because they have like that um oh, what did he call it? The place where I had it on my list actually. I didn't point out the whole list what Sawani has in uh Union Correctional doesn't have. They have this where they could keep a close eye on like people that maybe need medical. The one guy like brought up a thing like maybe he swallowed some batteries or something that he needed like direct supervision until he could be like kind of rehabilitated back into where he was, where he needed like supervision like that. They have a thing. I forget what it's called now. But anyway, Buffy, hey Buffy. Well, I'm going to read you the appeal. It's kind of interesting. It's a 127-page document, but for those of you that maybe are kind of new to the case or whatever that don't really know the facts of the case, it lays it out, but it actually I skimmed through it. I didn't even read through everything. I was skimming through to see what it was, and I had to get ready for this live. I'm like, ooh, should I read this stuff? So it does. I'm even skimming through. I noticed it had some like very specific details of the case that maybe kind of didn't get addressed in the court, like those. Okay, so I don't know how many in here are like me, have been following this case so closely, watched the trial, read every document of the case. I've been through all the documents of the case in the last year. I've watched the trial, I've watched everything, all the court stuff, I read all the court documents. So when I see something that's kind of like, oh wow, like little details, like, oh, I didn't know that little detail, whether it be important or not, like it's like, oh, that's a new little detail. So because basically the attorney general is laying out the whole case and he's being very specific on things. So there are some new little factors in there that I caught. And then they lay out the appeal part. So let's read it and see what they say about the appeal. So basically, Wade appealed it. This is their response to Wade's appeal. And now the circuit court will have to make their decision. I don't know, that's going to be a long, drawn out process, but this is what this is. So I wanted to read it to you guys. K-Court! New mod! Only Wadewood. Yeah, that was like an example that the one guy, Pino, said maybe he swallowed batteries or something, but it doesn't mean like he's off death row. Like you were saying, K-Court. Like it's not, he still has his death sentence. He still has to go through the appeal and we'll see what happens. Thanks for coming, guys. Let's read them up, Ern. That's crazy though, because there was like 150 people. Why isn't there 150 people in chat? It should have redirected all of them, but what, people just left after that? But I just want to point out about the calls real quick. Let me give a little bit of thoughts on those calls. How about when Rosemary says, they're twins. Everybody says that, they're twins, because at that point she thinks both are Wade's, her daughter and her son. And she's like, oh my God, they're like twins. Everybody's like, oh my God, they definitely have the same dad. Well, they don't, right? I mean, supposedly they don't. I don't like, who is the other girl's dad? Who's her daughter's dad? And was she with Wade? And how come was she cheating on Wade or something? Because how come she wasn't aware that it was somebody else? Like, you know what I'm saying? And she's like, on the phone, it sounds like she's so sure it's him. Like, yeah, they're identical. Like she has your face and my body. Like she really is convinced that they're Wade. So it's just kind of crazy. Now I did find her the child support papers, which we could go through that too. I was gonna do that a separate video, but maybe if I get through these, we could go through that and see what you guys think. The whole child support, it doesn't get into too many specifics because of the children, so it doesn't really say about like the DNA or any paternity test, but it does basically say that she was trying to get child support from Wade in 2023. So this would have been a couple years after these phone calls, and he appealed it. But then he didn't get the brief done. Like basically they dismissed his appeal. So I don't know when it came about that only one child was his, probably because he was trying to appeal it. And then was he the one that was like, wait, I don't think they're both mine or something? I don't know. I don't know how that came about. It's not in the documents, but we could go through those too. Yeah, that's true. I mean, he doesn't have money anyway. He doesn't have the money for child support anyway. So I don't know, like, how would that, I mean, why even do that when, how is she even going to get money from him? Or how would that work if somebody's in prison for the rest of their life, they have children, you can't get any money from them, right, CB? Okay, so she saw his good oh yeah, Joe, that's a good, wait, that would know, because that was in 2023. His GoFundMe wasn't until 2024, but that was a good thought, because I'm pretty sure the GoFundMe didn't get real big till 2024, right? Yeah, she was trying on in 2023. So remember, you guys, his trial wasn't until the summer of 2024, June, so that, I think that's when that's when all the women seen him. That's when the funly started. So this was like a year prior. So, I'll show you, but let's go through the appeal stuff first. The child support stuffs are really, we could get through those really quick, but I want to go through the child support or the appeal stuff. Okay. What 90s said, huh? I don't know what that means. What 90 said? In Australia, you can get a single parent support if you can't get child support. Oh, so she had to show maybe, huh? There's just not enough information, like, with the documents, it doesn't give you enough to understand all the specifics, which sucks, but I get it because some things they don't some things aren't public, so alright, let me share my screen. Alright, so we'll go through these here. The one's just 1 page, and the others are 127 pages, but like I said, it's a good refresher, and it lays out it's pretty interesting from just, like, going through it real quick, it looked pretty interesting. And I feel like there are still a lot of people watching now that don't know all this the facts of the case. There really you know what I'm saying? There really is people, and that's fine, you know? Okay. So here's the first thing. So this was all today. These were documents that were dropped today. Okay. So it says Supreme Court of Florida, it is hereby ordered that the Florida Department of Corrections transmit to the clerk of the Supreme Court of Florida forthwith the pre-sentence investigation, if any, done on the sentencing of the above appellant on August 27th, 2024. The pre-sentence investigation shall include a cover page that includes the defendant's name and sealed pre-sentence investigation in a 48-point bold font. It is preferable to transmit the pre-sentence investigation via the statewide portal. If mailed, the pre-sentence investigation shall be sealed in an interior envelope with the defendant's name and sealed pre-sentence investigation in a 14 bold font print in the front and the interior. Okay. So this is the one right here that's got all the good information in it. Okay, so let's start here. It shouldn't be too much, like it's 127 pages, but the print's pretty big. So I think we should be able to get through it. And it won't be like too much. You know what I'm saying? Where it's like, oh my God. Oh, I'm starting at the end. Okay. Because it's interesting. And like I said, it lays out all the facts of the case. And there's some like facts that are kind of new that I've never, or just like, I know the basics, but there's little things within it. Like maybe I'll point it out when there's little details that were like, oh, I don't remember that mentioned in trial. Like just like little tiny details of the case, which people that have been following for like a whole year, like when there's something a little new added, it's like, oh wow, I didn't think that there would be anything new to would come out. Okay, so here is the preliminary statement. It says citations to the record in this brief will be designated as follows. The record on direct appeal will be referred to as DAR, followed by the page number. References to the trial transcripts from the direct appeal will be referred to as DAT, followed by the page number. So record for direct appeal, DAR, and then the trial transcripts of DAT. CB, did you read all this? What did you think about it? Okay, statement of the case and facts. November 19th, 2019. Appellant was charged by indictment with 2 counts of first-degree murder for the deaths of Christine Melton and Diane Ruiz, and 1 count each of burglary of a dwelling, grand theft of a motor vehicle, simple battery, and petty theft. I always want to say petite. Okay, guilt phase. October 6, 2019. The night before her murder, Christine Melton and her friend. Wait, hold on. That was November. Just wanted to see that day. Okay. Anyway, the night before her murder, Christine Melton and her friend since high school, Stephanie Johnson, now Stephanie Sailors, left Melton's apartment in Cape Coral around 10 to 10:30 p.m. for the Buddha, a bar in Fort Myers. Appellant and Melissa Montanez. Remember, appellant is Wade. Okay. He's the appellant. Okay. So appellant and Melissa Montanez also went to the Buddha that night. Montanez drove them in her Dodge drove them there in her Dodge Hellcat. Melton and Johnson met the appellant, who showed an interest in Melton. He introduced himself, however, as JR. Yeah, remember he used to give that fake names? Ugh. Appellant introduced them to Jason, who appellant was with at the bar. So Wade was with Jason, but he had just met Jason at the bar. But to the women, they thought, remember Stephanie on the testimony, she thought in the moment that, that they were friends, because when she met him, he was with Jason. So she thought, oh, they must know each other. But in reality, he just met Jason at the bar. Anyway, So Appellant introduced them to Jason, who Appellant was with at the bar. The women assumed Appellant and Jason came to the bar. I spoke too soon. So he assumed that they assumed that Jason came to the bar together, him and Wade. But they met that night at the Buddha. At closing, Appellant told Montanez that he wanted to go to someone's home, but she did not want to go there and told him so. People were shuffled outside while Melton and Johnson were still socializing with the Appellant and Jason. Melton and Wade, I'm just going to call him Wade. So the Appellant. I mean, I'm just going to try to say Wade instead of the Appellant so you could follow up better. So Melton and Wade appeared interested in each other, and the two women followed Wade and Jason to a car because the group decided to after party. Although Wade did not have Montanez's permission to take her car, he tossed Jason the car keys because Wade cannot drive a stick shift, which I love that. Make fun of and the Hellcat is a stick shift. The four of them then got into the Hellcat and Jason drove them to his house. Although Jason's mother was home, they headed to his bedroom where Wade and Melton engaged in consensual sex, while Jason and Johnson hung out outside. After about 2 hours, Wade informed Melton and Johnson that they all needed to leave because Jason no longer wanted them there. They got back into the Dodge Hellcat, but Wade could not drive its stick shift. They called an Uber, but they were delayed while looking for Wade's cell phone, which they could not locate. Jason Shepard located the cell phone a couple of days later and turned it over to the police. They then drove to Melton's apartment. When they got there, Johnson informed Melton that Johnson had to leave to bring her son to school and be at work at 6 and left. Wade and Melton had sex with each other. Then Wade choked her to death. He wrapped up her body in clothes and sheets, left, and went to see Montanez. Wade texted and called Mila. So the Montanez is Mila. So he texted and called Mila that day from a phone number she did not recognize. They got into an argument about him taking her car. Eventually, she agreed to meet him so that she could get her car back. They met at her business, Mila's salon, but Wade was not in her car. She did not recognize the car he was driving, but she identified State's Exhibit 5, Melton's car, as looking like it. When Mila got out to speak with Wade, he tried to force her into the car. She resisted, but Wade then attacked her, punching her and choking her before fleeing. Wade then began driving around and decided, I've already done it once. Let's do it again. He picked up a female that he saw walking down the road, 1 block away from a school. He asked her if she knew where the school was at and could she show him. She told him it was right down the road, but said he could not find it. But he said he could not find it. She got into the car and they drove there. When they got there, he strangled her until she couldn't breathe anymore, but she did not die. While Wade drove around seeking a place to dump her body, she regained consciousness 3 or 4 times, which I don't remember it being 3 or 4 times. That maybe I missed that. I know she regained consciousness. I thought it was like basically 2 times because he said in the car she did. And then when he went to go, dump her into that yard, she did too. She started getting up after that. So that would be like 2 times, but this is making it seem like 3 or 4 times maybe in the car. Anyway, so he then pushed her out of the car and ran her over with it repeatedly. That's the horrible thing. Do you guys realize, any Wade wives in here, do you realize what Wade did? Do you realize when he pushed her out of the car, Diane was still alive and she actually started to try to get up supposedly, and he ran her over multiple times. Like, how is anybody attracted to this guy or supporting this guy? That is gross and horrible. I can't even imagine anybody could even do that. I can't. Okay. Patrick Power, who lives with his wife next door to the empty lot in Cape Coral, was home that morning. While eating breakfast in their lanai, he noticed a car back up and then drove forward before leaving. So he saw that, didn't even realize what he was seeing. Oh. Wade then returned to Fort Myers to Joe's Crab Shack. From there, Wade drove to see Josh, who owns Mateo Graphics. He arrived at Melton's car. Wade was wearing only sweatpants. No shoes, no shirt, and he was bloody. He was also frantic. He told Josh he needed a plane ticket and a bus ticket or anything. He was in a rush to leave as quickly as he could and stated that he had just done something horrific and killed people. He said he rolled up someone in a carpet or bedding and needed to get out of town. Josh questioned him about the fight with Mila in the parking lot, to which Wade responded, "You don't understand. I killed people." Josh lied and told Wade he needed to go pick up an employee at a job down the road and that he would be right back. Instead, he drove to another building, called the police and told them everything. He told him everything Wade said. Officer Chris was dispatched to Mateo Graphics after Josh's phone call. He searched for Wade but was unable to find him. The vehicle Wade drove there appeared to have blood on the passenger door. They also saw blood on the inside near the belt buckle. They ran its license plate, which came back to Melton. They tried to reach her without any success. They then dispatched officers to her residence to try and locate her. When the police entered Melton's residence, there was a huge bundle on the floor between the bedroom and the kitchen, made up of bed sheets and clothing. After they spread the sheets apart, they spotted the lower portion of a leg with a unique tattoo. When officers Caruso felt for a pulse, he realized that Melton's arm was already stiff. A forensic technician, Christina, processed the crime scene, packaging the items separately. A curtain rod with red stains on one end and the clothing in which the body was bundled were sent to the Florida Department of Law Enforcement for further testing. Detective Patricia Bell received a call from a detective investigating the incident at Mateo Graphics. She and other detectives were able to obtain an emergency contact from Melton, who then put them in touch with Johnson. Johnson confirmed that the black Nissan Versa at Mateo Graphics was Melton's. Detective Bell later collected a cell phone from Jason that belonged to Wade. When Melton's black Nissan Versa was processed, a cell phone was discovered in the glove compartment. Also inside the car, there was some discoloration on the plastic and the seatbelt. It was tested with phenolphthalein. I don't know how to say that correctly, which resulted in a positive presumptive test for blood. An additional cell phone was found underneath the driver's seat. Melton's registration was also located in the vehicle. Blood sample swabs from the passenger interior door of the Nissan were collected and sent to FDLE for forensic examination. Johnson dropped off her son around 9 that morning and went to work, where she arrived at 10 to 10:30 a.m. At one point, she texted Melton a message asking whether she was awake, but never received a response. Johnson spoke with Melton's cousin, Samantha, and asked if she had heard from Melton, but she had not. A few minutes later, Johnson received a call from the Cape Coral Police Department asking if she knew where Melton was and why her car was found in Fort Myers. Concerned about what may have happened to Melton after Johnson left her, Johnson, Samantha's husband, and another cousin of Samantha went to the Melton's apartment. When they arrived, the police caution tape was already up. Melton's car was not in the driveway where it had been the night before. They learned that Melton was dead. Wade called his biological father, Stephen, on October 7th, 2019, and asked him for help. Stephen was 14 or 15. Steve was 14 or 15 when he learned he was going to be a father. And Stephen and Wade's biological mother was younger than Steve. They put Wade up for adoption, and Wade was adopted by Candy and Steve Wilson, who went to church with Wade's mother. Steve and Wade connected with when Steve turned 18, or when Wade turned 18, sorry. All putting their names in. Okay, so Steve and Wade connected when Wade turned 18. After that, they began speaking to each other often on the phone, and one time, Steve went to visit Wade in Tallahassee. Wade asked often for money. When Wade called on October 7th, Steve was at work and was told by Wade that he had done something that he couldn't take back. Wade indicated that he and his girlfriend, who Steve knew as Mila, got into an argument. Steve thought that appellant was seeking help about that argument. He told Wade to call him back at dinner time. Meanwhile, Steve received a call from a detective who was looking for Wade, but Steve did not know why. He informed his wife about the calls. Later, Wade called back Steve and stated that Wade did something and that the two people were gone and would not be back. Wade added, "I'm a killer." But Steve thought Wade was making up a story because he tells stories, nor did he show any remorse. Wade called back a third time at 10. During the third call, Wade went into more detail about what he did. Wade told Steve that Wade had met a girl at a bar the night before. They went back to her house, hung out for a little bit, and then she fell asleep. After she fell asleep, he said he got on top of her and I choked that bitch, he said. He stayed in the house for a little while and then he rolled her up. He was going to try to put her in her car trunk, but he couldn't lift her body because rigor mortis had started to set in. He then left her there and took her car. Wade told Steve about a second woman he saw walking down the street, who he stopped and asked for directions and got in the car with him. Wade said that while he was driving, he reached over and choked her. He found a place to dump her body, but when he pulled her out of the car, he realized that she was still breathing. He said he got back in the car and ran over her until she looked like spaghetti. Steve testified that Wade sounded excited when he told the story. He seemed proud of it and did not show any kind of remorse. The whole time that appellant was telling Steve these details, the phone was on speaker and his wife was listening. Steve did not know where Wade was other than he was in a house that he broke into when he was running from the police. Steve told Wade that Steve was going to send him an Uber and needed the address of where he was. Wade gave him the address, which his wife messaged to the officer. She also relayed details about what Wade told him. They were still on the phone when law enforcement showed up at the house where Wade was. Steve encouraged Wade to go outside and turn himself in. Officer Tyler Whiddon testified that he works for the Cape Coral Police Department. On October 7th, 2019, while working at the Hector Cafarata Elementary School as a school resource officer, one of the fathers of one of the students gave him a purse that the parent found. When the officer Whiddon looked inside to see whose purse it was, he discovered it belonged to someone named Diane Ruiz. He was unable to reach her despite calling several times and leaving a voicemail. He asked a patrol officer to go by her house, which he did and spoke with her son. He learned that she worked at the Moose Lodge, which was across the street from the school. He went there to check for Ruiz, but was informed that she did not show up for work that day. Sergeant DeRusso testified that while searching with Officer Wilson for Ruiz, he spotted a vulture circling the area. When they drove to the area which it was circling, they spotted the dead body of Ruiz in the lot next to where the Powers lived. Master Corporal Nicholas Jones is a detective in the Major Crimes Unit. He and Detective Jason Hicks met with Wade at his request and recorded his statement. Post Miranda, Wade admitted to killing both victims. Wade stated that he had the first girl's phone and used it. He held her face up to the phone to unlock it, but it locked again after he used it. He wrapped her up because he was going to put her in the car, but she was too heavy. He added that the photo the officer showed Wade yesterday of the second victim is the same girl he picked up walking and killed. He started choking her when she told him to drop her off at the school. The autopsy of Melton was conducted by Dr. Noela Hernandez, Lee County's associate medical examiner. According to Dr. Hernandez, there was a darker bruise on the right side of Melton's neck, indicates that she had a blunt force injury or bruise on that side. Remember when I was reading her autopsy, it was like her right side had most of the injuries. The doctor observed some small bruises on Melton's neck, on the left side of her face, near her neck, as well as some small abrasions and bruises scattered on her torso and extremities. Melton had artificial nails, and some of the nails on her right hand were broken, so that the doctor could only see fragments of the artificial nail. Melton had a hemorrhage on the subcutaneous tissues of her neck and hemorrhage over the muscles on the neck. There was a hemorrhage in most of those muscles on the interior neck, which went all the way to the deeper muscles, as well as on the surface of the thyroid gland, which sits right over the thyroid cartilage. She testified that in order to make it go deep, there would have to be a stronger force used or a harder object or force. The more pressure, the deeper the damage or the deeper the injuries. There also were hemorrhages or contusions on both sides of the scalp and contusions on both lungs. Melton also had a small contusion on her transverse colon, which is part of the large bowel, and which is a blunt force injury. The damage to the interior of the scalp was also consistent with blunt force injuries. The lungs showed hemorrhage on the surface as well as extending slightly into the inside of the lung, which is also evidence of blunt force injuries. She also had a contusion to her liver and one to her bladder. She had a ruptured cyst in one of her ovaries, but the doctor could not say whether or not that was due to the trauma. There was also hemorrhage to the surface of the bladder that extended all the way to the mucosa, which is consistent with blunt force trauma. As was trauma to the liver, she also had petechia on her eyelids and petechia on her scalp, which taken together are consistent with death by asphyxia due to compression of the neck. The police collected a DNA bloodstain card at Melton's autopsy. It was sent to FDLE for forensic testing. Dr. Thomas Coyne performed an autopsy on Diane on the 11th of October 2019. Ruiz's external injuries included a broken nose, a laceration underneath her left breast, bruising or hemorrhaging in the skin on the left and right sides of the body, bruising on the back of her left forearm, bruising on the back of her left hand, a fracture of the fourth finger, and some bruising on her right arm. She had internal injuries, including bruising or contusions on the bilateral upper back regions or the trapezius muscles. There was also a hemorrhage on the right side of the neck within the fat tissue, as well as the sternocleidomastoid mastoid muscle on the right side of her neck. In addition, the left side of the hyoid bone was fractured, and the two horns of the thyroid cartilage were fractured. She has 2 sets of rib fractures on one side, 2 sets of fractures on the other side of her 1st through 11th ribs in both of the lateral and posterior aspects of the torso. She also had some interior rib fractures. Dr. Coyne opined that it would take far greater than 10 to 15 pounds of pressure to do that kind of damage because there were a corresponding fracture of the hyoid bone and the trachea cartilage. He also stated that a significant compressive type of force bearing down on her body was required to cause the multiple rib fractures. He agreed that an automobile driving over a body could cause that. Dr. Coyne also concluded that the damage to the thyroid cartilage and trachea are types of injuries that they classically see in strangulation, and it takes a tremendous amount of force to cause those fractures. He noted that it takes about 10 pounds of pressure to compress the carotid arteries that caused the hemorrhaging and prevented blood flowing to the brain. Dr. Coyne pointed out that the contusions and bruises on the backs of the hands and forearms would suggest that she was defending herself. Wow. He added that it takes 15 to 20 seconds for someone to pass out while being strangled. If, however, one releases the pressure, a person will regain consciousness. On the other hand, if that pressure is maintained for about 30 seconds, the person being choked may not return to consciousness because the lack of blood flow was persistent. He also concluded that because there was actual hemorrhage around the membrane between the first and the second cervical vertebrae, she was still alive at the time the force was applied. The doctor did not know the order in which the injuries happened, but testified that given the severity of the injuries to the neck, Ruiz could not have survived the injuries. A DNA bloodstain card was provided to the police at Ruiz's autopsy. Dr. Coyne was also involved in the autopsy of Melton and Dr. Hernandez. Melton had a large number of bruises on her body, a swollen eye, contusions around the eye, contusions around the mouth, and bruising all over her torso and arms. There was a significant amount of hemorrhaging on the skeletal muscles of the neck. She also had bruising all over her scalp as well as in the subscalp muscles, indicating significant blunt force trauma. So now we're talking about Melton again, Christine. The brain was swollen, which was consistent with the injuries to her scalp and around her head, which suggests that there was underlying concussive trauma. There were contusions of her internal organs as well, so forces that were direct to the outside of the body also went inward. Melton had bruising of the lungs, the liver, the back of her bladder, and her colon. This also indicated that there was a significant force to the abdomen. Melton died of asphyxiated from strangulation, but the existence of her brain swell suggests that there was concussive trauma to her head prior to that. Dr. Coyne also pointed out that any one of the multiple injuries could cause death, noting that the rib fractures alone would prevent normal chest excursion, limiting the ability to breathe normally and certainly could cause death. Blood sample swabs were from the passenger interior door of the Nissan were collected and sent to FDLE for forensic examination. Daniel Blaker works at the Indian River Crime Lab. He screens items of evidence for the presence of biological fluid and material, including blood, semen, saliva, and hairs, and attempts to develop DNA profiles from those items of evidence to perform DNA testing. He performed STR DNA analysis. STR is an acronym that stands for short tandem repeat. In Melton's case, he initially received buccal swabs from Wade. Buccal swabs. I hear people saying both ways. I don't know which way is proper. I've heard like doctors saying both ways. Um, yeah, it's crazy. CV, and these girls are all like sucking it up. Like, do it to me, do it to me. He would never kill me because I'm special. He wouldn't do it to me. That's what their mentality is. Like, oh, well, you would never do it to me. Like, kill me. You wouldn't take it that far. And then it makes him feel like special, like that he wouldn't or something. I don't know. It's sick. It's sick. Okay, so where are we at? In addition to that, he obtained 2 tied shirts, a shirt, a pair of jeans, and a bathing suit top that were tied together, along with an additional untied shirt, a curtain rod, and a bloodstained card from Christine Melton for comparison purposes. He used Wade's buccal swabs to obtain a complete DNA profile. He obtained a complete DNA profile on Melton from the bloodstain card. State Exhibit 16 is the shirts, the wrap bedding in black, white, and gray tied shirts. He sought DNA on the knotted portions because he was informed that they were used to tie up some apparatus of the victim. He removed and packaged what appeared to be hairs that he found on the items. He obtained mixed DNA from the first knot. The mixture included Wade as a possible contributor. It is greater than 700 billion times more likely that Wade, rather than another individual, is the contributor. Baker was able to obtain DNA from the second knot that demonstrated the presence of a mixture consistent with the 2 individuals. Wade and Melton are both included as possible contributors to that mixture. An observed DNA profile is greater than 700 billion times more likely to occur from Wade than another individual. Likewise with Melton. The DNA obtained from one knot in the bathing suit was 5.1 billion times more likely to have originated from Wade. The curtain rod tested presumptive positive for blood. Baker obtained DNA results and created a profile that matches DNA from Melton. From the handle, it demonstrated a profile which is greater than 700 billion times more likely to occur if it originated from Wade than any individual. So they're saying that blood stain on the rod was Christine's, if I'm understanding that right. And then the handle part would have been Wade's. So, I mean, we'll never know exactly what he did with that rod, but I know a lot of us have ideas of what he could have. It's just Baker also received a bloodstain card from Diane. He developed a profile for blood sample swabs from the passenger door that matched the DNA from Ruiz. After the state rested and the court denied a motion for directed verdict, the defense chose not to call any witnesses and rested. After closing arguments, the jury was instructed by the court and returned a verdict of guilty as charged as to all remaining counts. The penalty phase. The state argued that 4 aggravating factors applied to both murders in this case. Wade was previously convicted of a felony and was under sentence of imprisonment or on community control or on felony probation at the time he committed the first-degree murder in this. Number 2 was Wade was previously or contemporaneously convicted of another capital felony or a felony involving the use of threat of violence to another person. 3, the first-degree murder was especially heinous, atrocious, or cruel. 4, the first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense or of moral or legal justification. To prove the first aggravator, the state introduced a certified copy of the September 8th, 2019 judgment and sentence in case number blah, blah, blah. September, so that would have been copy of the September statement, judgment and sentence and the case number. So they're bringing up the other cases because the first aggravator is about him having another felony, right? How did they Wade was previously convicted of a felony, was under sentence of imprisonment or community control. So the first one, they're saying they brought up that case to show that he was contained in an order of probation. Wade then stipulated that he was lawfully placed on probation prior to and was on probation at the time of the offenses that resulted in his convictions in this case. To prove the other 3 aggravators, the state relied upon the guilt phase record. The state then presented 2 victim impact witnesses before arresting. Wade presented 2 expert witnesses, Dr. Hyman Eisenstein and Dr. Mark Mills. Dr. Eisenstein testified that he is a licensed clinical psychologist with a specialty in clinical neuropsychology and forensic neuropsychology. He reviewed criminal investigation reports in jail or other medical records. He also interviewed individuals in terms of their background and connection to this case, including the Wade, the appellant. So including Wade. He and Wade met on 3 occasions for a total of 7 hours. He noted that the records going back over 10 years indicated that Wade presented with numerous psychological symptomology. He added that Wade was on a variety of different psychotropic medications and is currently on lithium and Celexa, which are both psychotropic medications. According to his records, Wade has been diagnosed bipolar and diagnosed with depression, anxiety, schizoaffective, antisocial personality disorder, and adjustment disorder. He interviewed Wade's adopted parents, Steve and Candy Wilson, and also spoke to his older sister, Dr. Wendy Wilson. Dr. Eisenstein probably, huh? Also conducted testing on Wade. The tests on the first day included the TOM, test of memory malingering, the Delis Plan Executive Function System, the trail making test 1 through 5, and the letter fluency test. On the second day, he administered the word choice, another malingering test, the Ray Osterrath complex figure, the Welshler Adult Intelligence Scale, 4th edition, the Wide Range Achievement Test, 5th edition, and Wisconsin Card Sorting Test, the Weishler Memory Scale, 4th edition. Dr. Eisenstein also testified that Wade has a whole series of head injuries, and at age 20, he overdosed on drugs and had a grand mal seizure. He diagnosed Wade with having neurocognitive brain impairments, most likely right hemispheric and also frontal lobe involvement. So he had, not only did he have the drug overdose in his 20s, but remember he had one when he was in prison too, in 2019, 2020, forget what year was that, 2023? I don't know, but I think it was like April 20th around that or something, but he had one in jail, remember? But yeah, he had one. Saying he had one at the age 20 too. Um, hmm. Anyway, Dr. Mills testified that he is a psychiatrist and forensic psychiatrist. He attempted to interview Wade on 3 occasions, one of which was moderately successful, um, and 2 of which were largely unsuccessful. So he's basically saying only 1 really was successful. Okay. Um, he reviewed the same records as Dr. Eisenstein, but may have reviewed a few more witness statements. He also spoke to the adoptive parents, both mother and father, and Wade's elder adopted sister. He also read a letter that was authored by her. Dr. Mills administered the Minnesota Multiphasic Personality Inventory and the Personality Assessment Inventory to Wade. So he administered it to him, but the scores indicated that he was non-compliant by exaggerating symptoms that most people do not have, or most people do not have to that same degree, which invalidated each test. He diagnosed Wade with some kind of psychotic disorder, but because Wade was not particularly forthcoming with the doctor, he could not characterize it. He added that he thought it was very significant, or he thought it very significant. After Dr. Mills' testimony, the defense rested. In rebuttal, the state collected one expert witness, Dr. Michael Herkoff. Dr. Herkoff tested that he has a PhD in psychology. In this case, he reviewed police statements, investigative reports, medical records from when Wade was incarcerated, and interviewed Wade for over an hour. He also reviewed statements by Johnson and Testaseca. So remember, Johnson was Christine's friend that was there that night, and then Steve Testaseca is Wade's biological father. He also watched the video of Wade being interviewed by detectives. He viewed a timeline by Wade's adoptive mother and the records regarding his admittance to the Lee County Hospital. He reviewed emails that Wade exchanged with Kaylee Babowski, Andrea Lopez, Erica Anna, Alexis, Jessica. He spelled that wrong. We know who Jesse is, right? Copeland, Riley. So basically, they reviewed all these emails that we're actually reading right now. Okay. He also reviewed witness statements of the witnesses, Mila, Stephanie, Jason. So Jason Shepard is the guy that was out with him that night. Stephanie was the girl that was out with him. That was Christine's friends. And we know Mila. And then Amy. Wait, which one was Amy? Oh, Amy was Mila's friend that Mila stayed over that night with Amy, remember? So she went to her house that night. Josh, we know who Josh is, the one with Mateo Graphics. And then Steven Testaseca, which was Wade's biological dad, and Tyler Cruz. Which one was Tyler? When I gotta remember. Remind me who Tyler was. Why can't I think who Tyler is? K-Core. Who's Tyler? I can't think. Or Agem. You guys remember? Okay. He also reviewed the defense evidence. Dr. Herkoff did not agree that appellant suffers from any type of psychotic disorder or has frontal lobe brain damage. So I don't know if you guys remember that, but a lot of us watched that. We watched, the guilt phase or the penalty phase, where we watched the battle of the doctors, where he brought his saying he has like traumatic brain injury, all the freaking concussions and things that happen. And then the state's doctors like, no, I don't think he has anything, like as far as the traumatic brain injury, but he's also saying the psychotic disorder, which the state's doctor was so much more educated and informed. Like the doctor they brought in, what was the one guy's name? He was horrible. Like he might have been a good doctor, I don't know, but he was horrible at explaining things. I know, I remember Tyler. I just can't remember who he is. I'll have to look it up. Anyway, so Wade called Dr. Eisenstein and Dr. Mills on cerebuttal. Cerebuttal. Man, I feel like I got a burp. Hold on. Okay, so Wade called cerebuttal to testify about the raw testing data and medications, respectively, and then retested. Um, After additional argument from the state and defendant and instructions from the court, the jury recommended sentencing appellant to death. So remember, so this was before, so this was the penalty phase. What I was just talking about was the part after the jury said yes, death, and then the judge had to decide. Because remember, the judge doesn't have to always go by what the jury says. So the judge could, as far as sentencing, so the judge like took some time and like then he did the sentencing, but in between that time, remember, the defense wanted to run those tests. They wanted to get like a CAT scan and more MRI on his brain because they thought, well, before the judge decides death penalty, I want to show that he's got traumatic brain injury. So that was actually after the penalty phase, but before the sentencing, if you remember. Okay. Where are we at? So after additional argument from the state and defendant and instructions from the court, the jury recommended sentencing Wade to death for the murders of both Melton and Ruiz. The jury found the following aggravators regarding Christine Melton's murder. Wade was convicted of a felony and under sentence of imprisonment or placed on community control or on felony probation at the time of the murder. Appellant was previously convicted of another capital felony or of a felony involving the use of threat of violence to the person. Regarding Diane's murder, the jury found the following aggravators. Oh, and EHAC. Which one is that? Oh, the heinous, atrocious, and whatever. That's what I'm pretty sure that's what that one is. Okay, so then regarding Diane's, the jury found the following aggravators. Appellant was convicted of the felony. So that one, appellant was previously convicted of another capital felony or of a felony involving the use of threat or violence to the person. The HAC one, and then the CCP. The court found the following aggravators with regard to Christine Melton. Appellant was another one. Okay. So that's just repeating the same thing. Okay. The court found the appellant established the following mitigating circumstances and assigned them the following weight. Wade Wilson experienced the following mental health disorders: schizophrenia, schizoaffective disorders, delusions, paranoia, unaliva adjustment, or I hate that we can't like talk about that and use that word for education, because if like the bots just pick up you using that word, it gets like thrown into, I don't know. Anyway, so yeah, adjustment disorders, major depressive disorder, hallucinations, and perseveration. Little weight. Oh, thanks, Elvin. 12 months. Happy dance. Thank you. Wade Wilson confessed to law enforcement to do the right thing. Little weight. Wade Wilson wanted to put Miss Ruiz back with her family. Little weight. Wade Wilson is loved by his adoptive parents and sisters. Some weight. Wade Wilson's mental illness started as a child. Little weight. So these are all like how much weight. So like the fact that he did eventually like say where Diane was, like he wanted to put, no, I mean, it's bull crap, but I guess that's what they claim. And then when he confessed, but then, yeah, he confessed, but then now he's taking it back, you know? So the Wade Wilson is loved by his adoptive parents and sisters. Some weight. Wade Wilson's mental illness started as a child. Little weight. Wade Wilson was involuntarily committed when he was a teenager. Some weight. Wade Wilson tried to reach out to his biological parents when he became an adult. Little weight. Wade Wilson's biological parents were young and did not try to reach out to establish a relationship. Some weight. And 9, Wade Wilson was a loving son before mental health disorders. Little weight. You guys are understanding this, right? Like how much weight. So they're naming all this stuff. That's another thing that I don't remember hearing is that he was, where is it? Where's that one? Wade Wilson reached out when he became an adult. Wade Wilson became this one. He was involuntarily committed when he was a teenager. I don't remember hearing about that, but maybe I did, and I'm just like forgetting some of this stuff. And if I don't know, I just don't remember that part. Where are we at? Okay, so the mental health. The court sentenced Wade to death on both murders on August 27th, 2024. On September 15th, 2024, Wade filed his notice of appeal, from which this appeal follows. How's chat doing? Hey, Terminus Naw. Yeah, it's going to take a while. You're right. Okay, summary of the argument. Wade failed to properly preserve this issue. In any event, there is no ex post facto violation because the amended sentencing statute is purely procedural and does not change the substantive law. Also, the amended statute was not applied retroactively, but prospectively. Oh, prospectively. I was trying to say that. I read that weird. Yeah, prospectively under Florida law because the sentencing hearing occurred after the legislation effective date. So, however, Wade waived the argument that application violated section blah 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 Florida statute because he failed to raise it in the trial court. There's no violation of Ramos versus Louisiana because the case only requires a unanimous verdict to convict a defendant and does not apply to sentencing at all, let alone require a unanimous jury to recommend a death sentence. The aggravators and jury instructions provide sufficient guidance to avoid arbitrary and capricious sentencing. This argument is waived because it is not properly briefed. Regardless, the aggravator and instructions are not unconstitutional, either on their face or as applied to appellant, as applied to Wade. The jury instructions provide sufficient guidance to the sentencing jury to avoid applying the hack aggravator in an arbitrary, capricious, and inconsistent manner. Okay, so this argument is waived because it is not properly briefed. Regardless, the CCP aggravator and instructions are neither unconstitutional in their face or as applied to appellant because the jury instructions provide sufficient guidance to the sentencing jury to avoid applying the CCP aggravator in an arbitrary, capricious, inconsistent manner. This argument is waived because it is not properly briefed. Regardless, the victim impact evidence did not render the sentence unconstitutional because Florida statute only permits the type of testimony that the United States Supreme Court previously approved. In addition, because there were no contemporaneous objection to any of the testimony, Wade cannot complain that any particular testimony failed to comply with Florida statute. Standard of review. When the court conducts a review of the constitutionality of a statute, the review is de novo. Statler versus State. The court has held that questions of constitutional infirmity may be waived, but that an appellant may still challenge the facial validity of a statute for the first time on appeal because a conviction for the violation of a facially invalid statute would constitute fundamental error. All right, so we got Trushin versus State. Although this court warned in the opinion that prudence dictates that it be presented at the trial court level to assure that it will not be considered waived. The court further noted that a challenge to the constitutional application of a statute must occur at the trial level, explaining, however, that once an appellate court has jurisdiction, it may, if it finds it necessary to do so, consider any item that may affect the case. Okay, so while the constitutional application of a statute to a particular set of facts must be raised at the trial level, a facial challenge to a statute's constitutional validity may be raised for the first time on appeal because a conviction for the violation of a facially invalid statute would constitute fundamental error. Anyway, when the court considers a facial challenge, its review is limited. The court considers only the text of the statute, not its specific application to a particular set of circumstances. For an appellant to succeed on a facial challenge, he has a high burden. He must demonstrate no set of circumstances exists in which the statute can be considered constitutionally valid. A facial challenge requires a plaintiff to establish that no set of circumstances exist under which the law could be valid. Wow. Or show that the law lacks a plainly legitimate sweep. As a result, a law will not be invalidated as facially unconstitutional simply because it could operate unconstitutionally under some hypothetical circumstances. Wow. Abdul at 538. Also, the court has specified that legislative acts are afforded a presumption of constitutionality, and we will construe the challenge legislation to affect a constitutional outcome when possible. The court also conducts de novo review of the interpretation of a statute, but must give the statutory language its plain and ordinary meaning, and it is not at liberty to add words that were not placed there by the legislature. A court's determination of the meaning of a statute begins with the language of the statute. If the language is clear, the statute is given its plain meaning, and the court does not look behind the statute's plain language for legislative intent or resort to rules of statutory construction. Where a statute does not specifically define words of common usage, such words are construed in their plain and ordinary sense. A statute is void for vagueness. When persons of common intelligence must guess as to its meaning and differ as to its application, or if it lends itself to arbitrary enforcement at an officer's discretion. Yet, the legislature failure to define a statutory term does not in of itself render a provision unconstitutionally vague. Sorry, guys, you guys following? Also, this part's a little like a wordy, you know. Also, a statute must not be unreasonable, arbitrary, or capricious. It must have a reasonable and substantial relation to a legitimate government objective to survive review for compliance with substantive due. I might skip. A statute is overbroad when legal. Constitutionally protected activities are criminalized as well as illegal. Unprotected activities, or when the legislature sets a net large enough to catch all possible offenders and leaves it to the courts to step inside and determine who's being lawfully detained and who should be set free. Finally, the complaining party bears the burden of demonstrating the trial court error and that it was preserved by proper objection. Only when the defendant satisfies the burden of demonstrating the existence of preserved error does the appellate court engage in a de guilio harmless error analysis. If the error is not properly preserved or is unpreserved, the conviction can be reversed only if the error is fundamental. Got it? Okay. Now we have argument issue 1. The trial court did not violate the ex post facto clauses of the United States and Florida Constitution or the terms of Florida. So Wade, the appellant, contends that his death sentence violates the ex post facto provisions of both the United States and Florida Constitutions. He argues that applying the April 2023 amendment to section blah 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 Florida statutes that eliminating jury unanimity. So this their whole thing is because the law changed. You have to have it unanimous, or you had to, and now you don't. But back then, when the crime got committed, you did have to. So anyway, it eliminated the jury in death sentencing and penalty phase of his trial for murders he committed in 2019. It violates both post facto principles and the express terms, prohibiting retroactive application of the amendment. But because the amended statute does not criminalize an act that was previously innocent, does not increase the potential sentence of an existing crime, and does not alter the proof necessary to impose the death penalty. So it is not an post facto law. Appellant Wade cannot demonstrate that applying the amended statute violates section 775 Florida statute because contrary to his assertion that the amendment was applied retroactively, according to this court's precedents, it was applied prospectively. Finally, because appellant failed to either raise in the trial court below an argument that applying the amendment statute violates section 775 Florida statutes or cite to whether in the record he did, he must demonstrate the trial court committed fundamental error when it applied the amended statute and is unable to do so. And he is unable to do so. Let me take a sip of this. I'm trying to like understand. Okay, so it was so it had to be unanimous. And then when he did the trial, when he committed the crime, it was still under the old, or should it be still under like those rules where it had to be unanimous? That's what they're arguing instead of going by like now fast forward, here's the new law, but the crime was committed in 2019. It's tricky, but I mean, it doesn't look like, because remember we read some histories of people trying to appeal it, and it doesn't look like that you can't. I mean, you could try, but it doesn't look like they win, at least the couple that we read, I don't think they were able to get it taken away, right? I'm trying to remember what it said. I read it like, I don't remember, a few months ago, or it might have been like 5 months ago. They've been doing this case for so long. Anyway, the trial court's ruling correctly determined that applying the amendment, the amended did not violate ex post facto principles. The United States Constitution prevents both Congress and any state from passing any ex post facto law. Let's see. The Florida Constitution contains a similar limitation. On January 11th, 2024, Wade filed a motion seeking that the trial court apply in his case the version of Florida statute in effect prior to April 23rd, 2023 amendment. In the motion, he argued that the proper law to apply, was the law in effect at the time the crime was committed, and that applying the amended version of the statute violated the ex post facto provisions of both the United States and Florida constitutions. The trial court denied the motion on March 14th, 2024. The court, in its decision, relied on Daubert versus Florida. Wait, on March 2024? Hold on, wait. Amendment in motion, he argued that motion on January 11th, 2020. Okay. Hold on a second. Because isn't wait, why am I like getting my dates wrong then? Because are they talking about somebody else? Factual law, Constitution of Florida, seeking the trial court apply his case. Because wait, the trial, okay, we're in 2025. What that would have been he wouldn't even had the trial yet by then. Am I like well, are you guys following me? They can't be. Are they just talking about a different case? Right here, because it says on January 11th, 2024, appellant filed a motion seeking the trial court apply, in his case, the version of, I guess he could have said it before the trial, like seeking that version, but this would have been before he got convicted and then a death sentence because the trial was June 2024, right? It was just this, it was last summer. So January 2024, why would he be filing it then? And then March, I don't know. That's maybe they meant to put 2025. Is it a typo or something? Anyway, the trial court denied the motion on March 14th, 2024. The court in its decision relied on Dauber versus Florida. I feel like those were supposed to be 2025. Because why would he be doing this before he even got the death penalty, right? Maybe that's the only option is maybe they're trying to do it before just in case because it was on the table. It was a possibility if he got convicted. So maybe they did it ahead of time. But that's the thing, it surprises me how bad his lawyers really did suck. I feel like because I feel like they just realized like it's such a strong case against him. I do think he had pretty sucky lawyers. So it just surprises me that they would have like done this proactively. You know what I'm saying? But anyway, okay. So where are we at? The court concluded that because the amendment to the Florida statute does not criminalize an act that was previously innocent, does not increase the potential sentence of an existing crime. And does not alter the proof necessary to impose the death penalty. The recent change to the statute, although Wade contends that the trial court's use of the newly amended statute, rather than the version that was in effect when he murdered Christina Diane in 2019, violates the ex post facto clauses of both the United States and Florida Constitution. The trial court properly relied upon Daubert, in which the United States Supreme Court previously rejected a similar claim, finding that the ex post facto principles were not violated when Florida applied an amended death penalty statute to a murder that occurred before the amendment. All right. In Daubert, the defendant murdered his young daughter in December of 1971, and then his young son sometime early 1972. At the time of the 1971 murder, Florida's death penalty statute provided that a person convicted of a capital felony was to be punished by death unless the verdict included a recommendation of mercy by a majority of the jury. After the murder, the United States Supreme Court in Furman versus Georgia struck down capital punishment as violating the Eighth Amendment. In response to Furman, many states, including Florida, enacted a new death penalty statute. Daubert was convicted of the first-degree murder of his daughter and sentenced to death using the post-Furman amended death penalty statute enacted after he committed his crimes. Among Daubert's claims raised were ex post facto challenges to Florida's amended death penalty statute. Daubert at 287. His ex post facto challenge relevant to the court's consideration of this case, modifications made to the function of judge and jury in opposing a death sentences was a similar challenge to the one appellant opposes here. So it addressed the constitutionality of applying the change made between the time he committed the crimes and the time he was sentenced for them. Supreme Court noted that even though a procedural change may work to the disadvantage of a defendant, a procedural change does not create ex post facto concerns. The court concluded that there were no ex post facto violations because the changes in law were procedural and ameliorative in the sense that the changes were a benefit to the defendant. But were they for some? I mean, I guess it depends on benefit to the defendant. Okay. The court found the amendments to Florida's death penalty statute were procedural because they merely altered the methods employed in determining whether the death penalty was to be imposed. There was no change in the quantum of punishment attached to the crime. All right. So, as the court noted, the crime, the punishment, and the quantity or the degree of proof necessary to establish his guilt all remained unaffected by the amendments. The court also addressed a similar claim concerning section blah 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 Victorino versus state. At the time the statute was challenged, it had been amended to provide for juror unanimity. Word good, don't make fun of me. In determining what aggravating factors existed. The sufficiency of the aggravating factors for the imposition of death, if finding that the aggravating factors outweigh the mitigating circumstances in the recommendation of a death sentence. The court relied on criteria the Supreme Court enunciated in Lynn versus Mathis to determine if a criminal law should be deemed ex post facto. The court found that for a criminal law to be ex post facto, it must apply to events that occurred before it was enacted. So they're saying it must apply to events So that would be, I guess it'd be the same because this would be before this would be enacted. Okay. And it must alter the definition of criminal conduct or increase the penalty by which a crime is punishable. But okay. It's hurting my head a little bit. Now, if like I was reading this by myself, I'd be able to like figure it out. But sometimes since I didn't get to really read this all to myself, I'm kind of reading it new with you. Like it's hard to absorb it when I'm just reading it out loud. Because if I'd read it to myself, I'd be like, I don't know, reading it over a couple times and getting it right in my head. Okay, so to fall within the ex post facto prohibition, a law must be retrospective. Okay, and it must disadvantage the defendant by altering the definition of criminal conduct or increasing the punishment for the crime. I just don't get that because it is increasing though. I mean, I get how they're laying it out, like it's not increasing the punishment. But like you could look at it a different way because it kind of is, because death is thought of as like an increase in life. So like the way to determine that. So with the old law, his punishment would have been life. With the new one, it's death. So it is increasing it. But I get how they're like laying it out. by saying it's not an increase, but it's still tricky, dude. It really is. The court denied that the Victorino was entitled to any relief, holding that applying the amended statute did not implicate any ex post facto because the amendment neither alters the definition of criminal conduct nor increases the penalty by which the crime of first degree murder is punishable. I mean, okay, I get that, but additionally, the Florida district courts that have examined the merits of precisely the same claim or the same claim Wade raises here have all concluded that applying the newly amended version does not violate it, the ex post facto. Okay. I'm going to skip some of this because it's saying basically the same stuff. Okay. So, yet the appellant argues that the United States Supreme Court's decision in Collins versus Youngblood calls into question any decisions predating Collins, which may have relied on a distinction between procedural and substantive law, because the court noted that by simply labeling a law procedural or legislature does not thereby immunize it from scrutiny. God, my head hurts. So appellant's reliance on this comment to contend to the court's decision is no longer valid. Well, okay, I'm gonna skip. What do you guys think about that? Like, just take Wade out of the occasion, like how your hate for Wade, and just take that the specific case, but just in general, this law. Like, what do you think about it? How they're going back? So, like, the crime happened when it would be he would have at that time, the law at that time was it had to be unanimous for him to get the death penalty, right? So like that 20 and wasn't it 2023 when they changed that? So basically it happened what 4 years before the law changed. So like I mean, what's your thoughts on it? You think that should be allowed? It's tricky. I mean, I get the point why it seems like, well, wait a minute, but I mean, okay, let's see what this says. The law in question was clearly procedural, but because it simply altered the methods employed in determining whether the death penalty was imposed. There was no change in the quantum of punishment attached to the crime. Okay. This argument also ignores the Supreme Court's decision in Lentz versus Mathis. The court pointed out that the disadvantage to the defendant must be by altering the definition of criminal conduct or increasing the punishment for the crime. This court should note that Lentz and Mathis was decided 7 years after Collins. Okay, let's see here, guys. Sorry. Oh, wait, that might be interesting. So it says the court concluded the prohibition, which may not be evaded, is the one defined by Calder categories. These include laws that make criminal an action which was innocent when done. Okay, so I get that. So they're laying out. Okay, so if it would go against it, if it made criminal like an action which was innocent when done, aggravated crime or make it greater than it was when committed. Okay. Um, inflicted greater punishment than when the crime was committed. So I get that. So what they're saying is let's say like if it was like second degree murder or like something that you can't carry a death sentence. You know what I'm saying? And then it's like more than a greater punishment than the crime that was committed. Like you can't change the punishment. So the punishment normally for this would be this or that. But if the rule changed to a higher degree of what you could get for the crime, you can't do that. So that's how they're laying it out like that. That would increase the punishment. Where the first degree murder with all the mitigating circumstances and stuff, that is the punishment for that kind of a crime. So it's not increasing a punishment, but all right, different testimony. So then or alter the legal rules of evidence to receive less or different testimony than the law required at the time of the offense was committed in order to convict the offender. Um, hmm. So yeah. All right, let's see here. I'm going to try to get back to the next. What do you got? Let me see what you guys are saying. Does anybody think that, like, just take this case out of it, but does anybody think that they shouldn't be allowed to do that? Or no? Do you think that you should be allowed? I know, like, legally they're showing it, yeah, I mean, they didn't do anything, but, like, do you think, like, that seems right? That it should be like that is what I'm asking? I just want your opinion, guys. I don't know. I mean, I could see both sides, I guess. Um, it says the changes to Florida's death penalty sentencing procedures are purely procedural. They do not make criminal an action which was innocent when done. So they don't do that, or they don't aggravate a crime or make it greater than it was when committed, inflict a greater punishment than when the crime was committed, or alter the legal rules of evidence to receive less or different testimony than the law required at the time of the offense was committed in order to convict the offender. As a result, there was no ex post facto violation. But remember, this is the other side arguing for their side, that they're saying, no, this should keep, that, like, they're arguing against his appeal. You know what I'm saying? So then the court has to decide, ooh, what are they going to decide? I don't know. I mean, I don't know. Okay, because appellant failed to present to the trial court any argument that Florida was violated, he must demonstrate fundamental error in the court's application of the statute. To preserve an issue for appellate review, the specific legal argument or ground upon which it was based must be presented to the trial court. Okay. Explaining that to preserve an issue for appeal, the presentation in the lower court must be sufficiently precise that it fairly apprised the trial court of the relief sought and the grounds therefore. In addition, a party must obtain a ruling from the lower court to preserve the issue. Except in cases of fundamental error, an appellate court will not consider an issue unless the appellant presents the issue to the lower court. Appellant fails to cite where in the record he presented it to the trial court, his argument that applying section blah, 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 as amended violates section. So he's got to present an issue to the lower court. Okay. As a result, the only conclusion that the court can reach based on the party's briefing is that the appellant did not present this argument below. Judges are not like pigs hunting for truffles buried in the record. Because Wade did not present this argument to the trial court, this court should limit its consideration of his argument to whether he has demonstrated that the trial court committed a fundamental error by applying section blah, blah, blah. Okay. C, the trial court did not commit fundamental error because it prospectively applied the 2023 amendment of Florida to appellant's 2024 penalty phase as required. So I get that, though. See, that's a good argument because the penalty phase was after. So the crime, wasn't in time of the crime, but for the penalty phase, that law's already there for, you know what I'm saying? So I think that's why, obviously why, he didn't. But didn't we read a case where, hold on, somebody appealed it because the penalty phase? Wait, if that makes sense, hold on. Maybe not. I got to think about that. Okay. Is the intent of the legislator that the section preclude the application of the common law doctrine of abatement to a reenactment or an amendment of a criminal statute? An act of the legislature reenacting or amending a criminal statute not be considered a repeal or implied. Used in. Are you guys, you want me to read all this? You want me to skip some of it? Because it's very wordy, like, as used in this section, the term criminal statute means a statute, whether substantive or procedural, dealing in any way with a crime or its punishment. Defining a crime or defense to a crime or providing for the punishment of a crime. Except as expressly provided in an act of legislature or as provided subsections 4 and 5, and reenactment of amendment or of a criminal statute operates prospectively and does not affect or abate any of the following: the prior operation of the statute or a prosecution or enforcement thereunder, a violation of the statute based on any act or omission occurring before the effective date of the act, prior penalty, prior forfeiture, prior punishment incurred or imposed under the statute. If a penalty, forfeiture, or punishment for a violation of a criminal statute is reduced by reenactment or amendment. All right, I'm going to skip some of this. Sorry, guys. See, this kind of, some of the more legal stuff I have to like read on my own to absorb it. I mean, I could just read it to you guys, but then I don't know. I think it'll be better if we skip through some of this so I could get maybe to the child support stuff too. Unless you guys want me to, let me know. Okay, so it's basically almost like saying the same things over and over in a way. Same points. Okay, so let's skip down to issue 2. Does not require unanimous jury recommendation of death. So this Ramos versus Louisiana. Next argues that the 6th and 8th Amendments to the United States require a unanimous determination to sentence to death a convicted party. He erroneously relies on the Ramos versus Louisiana. So they're saying Wade is arguing this, and he's relying on this case here for the premise and urges this court to reconsider its holding. But Ramos only considers the need for jury unanimity under the 6th Amendment in reaching a conviction. And it does not even address the 8th Amendment. Okay. So if the 6th Amendment's right to a jury trial requires a unanimous verdict to support a conviction in federal court, it requires no less in state. Okay. A, because appellant failed to present to the trial court any argument that a non-unanimous jury recommendation violated the 6th and 8th Amendments, he must demonstrate to the court committed fundamental error in sentencing appellant to death without unanimous jury recommendation. Specific legal argument or ground upon which it is based must be presented. Okay, let's see. So, let's see. The presentation in the lower court must be sufficiently precise that it fairly apprised the trial court of relief sought in the grounds therefore. In addition, a party must obtain a ruling from the lower court to preserve the issue. All right. Yeah, they're kind of saying the same things. Oh, it says the court has never held that a jury's sentencing recommendation requires unanimity. Why can't we say that word, guys? See, I could do the Google pronunciation, and I could usually say it right after them, but then when I try to re-say it, there's just certain words. Are you guys like that? That's one that sometimes it's just certain words at certain times. Like sometimes it's like, oh, I could usually say this word, but today I can't. But this word I can never say. Hold on, let me see how I have to listen to it, and then but then like I try to redo it like later, I'll still have trouble with it. Let's see how. But if you hear it, you're able to kind of say it as you hear it, and that's why I like these Google sounds. You guys use them? Unanimity. it's hard, guys. Hold on.
Unanimity.
Unanimity. See? But watch. Now it comes in another 5 minutes. I'll struggle again. Unanimity. Even if I say it over and over.
Unanimity.
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 Unanimity. Don't make fun of me, guys. We all probably have those words. I don't know why, like maybe certain people's mouths just does. I don't know what it is.
Unanimity.
Unanimity. Unanimity.
Unanimity.
Unanimity.
Unanimity.
Unanimity. Unanimity. Okay. I still won't do it. Okay, so court has never held that the jury's sentencing recommendation requires unanimity. Oh, you don't think she's saying it right, Ajam? Oh, how do you say it? Unanimity? Anyway, okay. Correctly receded from his previous opinion, holding differently, contrary to appellant's arguments otherwise. All right, we got to skip through some of this, guys. Whereas capital sentencing scheme impermissibly allowed sentencing judge to find an aggravated circumstance independent of a jury's fact finding. That is necessary for imposition of the death penalty. But the court pointed out the decision in Ring has nothing to do with jury sentencing. The court added, as a Justice Scalia explained, the states have that leave the ultimate life or death decision to the judge may continue to do so. If a judge without any jury involvement may sentence a person to death, then it defies logic to conclude that a jury's decision, let alone its recommendation, is constitutionally required by the Sixth Amendment to be unanimous. That's a good point, because think about it. The judge has the ultimate decision. He could have said no death penalty. So they're saying if he has that power, if he could, let alone, how do they word it? Without any jury involvement, then how can they say that if the jury isn't unanimous, that the Sixth Amendment? Yeah, are you guys following it? Now I can't talk right. So that's a good point. But then it says, as the Supreme Court explained, it held that capital defendants are entitled to a jury determination of any fact on which the legislature conditions an increase in their maximum punishment. All right. So the appellant's argument that the Eighth Amendment requires a unanimous jury recommendation of death is a bit murky. It appears to rest on appellant's characterization of the plurality's opinion in the Ramos as having emphasized that unanimity enhanced the quality of juror deliberation. But wait, to rest on appellant. And expressed racial concerns of non-unanimity. But even if appellant's characterization of the opinion is correct, the court's plurality opinion in Ramos never addresses sentencing or the Eighth Amendment. Thus, appellant's contention that Ramos requires a unanimous jury recommendation for a death sentence under the Eighth Amendment is as unreasonable as his contention that Ramos requires it under the Sixth Amendment. Even under the Eighth Amendment, jurisprudence requiring increased reliability in capital cases, unanimity. Stop it. I feel like a little kid because I can't say a word. Is not required for a sentencing recommendation. Unanimity. Can I say a different word for that? What can I say for that? Because I can't just keep saying it over and over. It's driving me nuts because I can't say it right. Midity. I'll just say midity does not increase reliability or accuracy in capital sentencing. I mean, that's a good point too. The dissent in Ramos pointed to the rogue jurors as a good policy reason to allow non-unanimous verdicts. Justice Alito observed that the prominent scholars, some of whom relied on military court marital verdicts, advocated it non-unanimous verdicts in part due to their increased reliability. What? Huh. Why would that be, though? Re- Increased reliability. Huh. I mean, I don't know if it would be increased though. Yeah, unanimous wouldn't increase it, but I wouldn't say that. I don't know. I mean, non-unanimous wouldn't make it more, or unanimous wouldn't make it like increased reliability or how do they word it? What do they say? Or accuracy, but it wouldn't be also ununanimous wouldn't increase it either. Do you see what I'm saying? I wouldn't think. Anyway, the problem posed by rogue jurors and such jurors' ability to undermine reliability and accuracy. Huh. So the more importantly, the plurality relied exclusively on the historical requirement of unanimity for conviction at common law and in the federal courts. The plurality, that's another one I'm having trouble saying, admitted that it was not any cost benefit analysis or any determination regarding whether unanimity was important enough or an Eighth Amendment concern regarding reliability that mandated its holding. Oh my God. Yeah, my mouth's getting tired. Sometimes I'm to a point now I can't say more words. Okay. The jury had no role in capital sentencing at common law or historically in America. The jury's role was limited to convicting a defendant of a capital crime. A judge alone sentenced the defendant to death, and that death sentence was often mandatory. So they're saying, yeah, huh. Yeah, that's interesting. Yeah, I mean, that's a good point. Observing that at common law, all homicides that are not involuntary, provoked, justified, or excused constituted murder and were automatically punished by death. Indeed, at the time the Eighth Amendment was adopted in 1791, the states uniformly followed the common law practice of making death the exclusive and mandatory sentence for certain specified offenses. Based on common law and history, the argument that a jury must be involved in any way in capital sentencing necessarily fails. To the extent that the appellant relies on the reasoning in this court's opinion in Hearst versus State, this court correctly dismissed the reasoning in State versus Poole. As we have explained, the Supreme Court in Spaziano upheld the constitutionality under the Sixth Amendment of a Florida judge imposing a death sentence, even in the face of jury recommendation of life, a jury override. It necessarily follows that the Sixth Amendment, as interpreted in Spaziano, does not require any jury recommendation of death, much less unanimous one. And as we have also explained, the court in Hearst versus Florida overruled Spaziano's only to the extent it allows a judge rather than a jury to find a necessary aggravating circumstance. It cannot, even with Spaziano, the Apprendi line of cases cannot be read to require a unanimous jury recommendation of death. Those cases are about what facts, those that are equivalent of elements of a crime, the Sixth Amendment requires to be found by a jury. Sentencing recommendations are neither elements nor facts. As Justice Scalia said, the judgment in Ring And by extension, the judgment in Hearst versus Florida has nothing to do with jury sentencing. Finally, we further erred in Hearst versus State when we held that the Eighth Amendment requires a unanimous jury recommendation of death. The Supreme Court rejected that exact argument in Spaziano. The Constitution permits the trial judge acting alone to impose a capital sentence. We are bound by Supreme Court precedents that construe the United States Constitution. I gotta take some water, guys. Hold on. And like it says, the reasoning is supported by the Supreme Court as well as the court has explained. While aggravators are purely factual determinations, mitigators are largely a judgment call or perhaps a value call. And the ultimate question of whether mitigating circumstances outweigh aggravating circumstances is mostly a question of mercy. Rejecting Eighth Amendment claim that a capital jury had to be instructed that mitigating circumstances need not be proven beyond a reasonable doubt. Similarly, as this court has explained about Florida's capital sentencing law, the jury sentencing recommendation is not a fact, although it may involve factual findings concerning the existence of aggravators. The recommendation consists largely of deciding the mitigation, then weighing the aggravation against the mitigation found. As a result, this court correctly concluded that a sentence recommendation is moral judgment, because a jury sentencing recommendation is a moral judgment rather than a factual finding. A sentencing recommendation is not the equivalent of a guilty verdict. The court should reject the appellant's claim that Ramos requires juror unanimity in recommending a sentence of death. I can't do another. Yeah, we're going to skip this because it's going through the stuff that they already listed, that third one. So it's just going to be a lot of repeating and bringing up cases of that. So I'm going to skip that part real quick. Let me make it smaller so I can see what I'm working with here. This one might be interesting. So issue 4, appellant cannot demonstrate that the heinous, atrocious, or cruel. So that's what that hack stands for. Heinous, atrocious, or cruel aggravator or its corresponding jury instruction is unconstitutional either on its face or as applied to him. In its claim, appellant argues that hack aggravator is unconstitutional both on its face and as applied to him. His entire argument consists of quoting verbatim the first 6 paragraphs of his 7-paragraph motion filed in the trial court, in which argued that and its accompanying jury instructions are unconstitutionally vague and overbroad, are not capable of constitutionally narrowing instruction, and can only be applied in an arbitrary and inconsistent manner. The motion concludes that the vague statutory language of this aggravating factor and its corresponding jury instruction allows imposition of a death penalty for improper and unconstitutional reasons such as race, gender, ethnicity, religion, and social status. Appellant Wade, however, waived this argument by failing to properly brief this claim. But even if he had not waived it, the claim would fail because he has failed to demonstrate that the hack aggravator and jury instruction are unconstitutional, either on their face or as applied to the appellant. And this is appellant Wade merely refers to his argument below without any of the further elucidation that is required to properly argue his claim. So you're saying the hack aggravator is unconstitutional. A copy of all but 1 paragraphs of the motion he filed in trial court asserting that hack aggravating factor is unconstitutional in the following 2 sentences. In the instant case, the jury found that the hack aggravating factor applied to both murders for the reasons articulated by defense counsel below. Appellant Wilson asserts that Section 921 is unconstitutional. The court has long held that simply referring to arguments presented in a motion in a lower court without further elucidation waives a claim. As the court explains in Duest also seeks to raise 11 other claims by simply referring to arguments presented in his motion for post-conviction relief. The purpose of an appellate brief is to present arguments in support of the points on appeal. Merely making reference to arguments below without further elucidation does not suffice to preserve issues, and these claims are deemed to be waived. So it's basically saying the penalty phase, failing to challenge the penalty phase. Okay, wait. Yeah, I'm gonna skip some of this because a lot of when they're going about other cases. So it says, concerning facial challenges, the court explained that when we say that a statute is facially unconstitutional, we mean that no set of circumstances exist under which the statute would be valid. Huh. All right. Sorry, guys. We're going to skip. Oh, okay. So here's back to this case. So it says, the sentencing order describes how victim Christine Melton was severely beaten, battered prior to being suffocated to death. She was struck on both sides of her head, causing brain swelling that could only have occurred if she were still alive at the time she was beaten. She also had defensive wounds and blunt force injuries to her face and parts of her body that were unrelated to being smothered, indicating that she struggled before she was murdered. The sentencing judge concluded that the totality of the evidence indicates that she was conscious and aware at the time she was both battered and strangled. Oh, hold on. Gosh, she's horrible. I just want to see if I missed, because they're talking about now specific. I like when they refer to the case we're talking about, because when they name other cases, sometimes it could get like, oh, too much. But I get it. I mean, it's important. But so I'm going to read the paragraph before. It says, additionally, the hack aggravator is constitutionally applied to the appellant individually as well. Wade was convicted of 2 murders that both involved him strangling his victims. Under this court's express interpretation of the law, death by strangulation constitutes prima facie evidence of hack. And then that I read, and then we'll go. Okay, the sentencing order also describes that that victim Diane Ruiz was conscious and aware she was being suffocated at the time of her death. Wade attempted to suffocate her several times, but she kept regaining consciousness. Each time she regained consciousness for what would have been for at least 15 seconds. Ruiz attempted to fight off appellant, as evidenced by the defensive injuries to her hands, arms, and her broken nose. As to what the trial judge described as the most horrifyingly, when she actively attempted to flee from the attacks, Wade ran her over with his first murder victim's car, breaking all but one of her ribs and inflicting life-ending injuries to her neck and cervical spine. The court concluded that the appellant's killing of Ruiz showed extreme and outrageous depravity as exemplified either by the desire to inflict a high degree of pain or utter indifference to or enjoyment of the suffering of another. Undoubtedly, the crimes were committed by Wade in a conscienceless or pitiless manner. When he later recounted his savage acts to his father, he was excited about what he had done and expressed no remorse. Even when victims died quickly, If they are conscious of their attacker and aware of their impending death, the hack aggravator applies. C, harmless error. Even if the court concludes that the trial court's finding of hack was made in error, such an error would be harmless. When the court strikes an aggravating factor on appeal, the harmless error test is applied to determine whether there is no reasonable possibility that the error affected the sentence. Jennings versus Stace. Okay, so striking an aggravator necessitates a harmless error analysis. The trial court found 4 aggravating factors in the death of Rez, including hack. The capital felony was committed by a person previously convicted of a felony, was under sentence of community control or on felony probation at the time of the offense. 2, the defendant was previously contemporaneously convicted of another capital felony or a felony involving the use of threat, violence to the person. 3, hack, heinous, atrocious, and oh my, I already forget the C. Remind me, guys. Heinous, atrocious. Probably because this is my second live. I'm like 4 hours into lives because I did the first one. Well, I mean, I guess that was a premiere. But when you read this, whew. Okay. And CCP. The trial court found 3 aggravating factors in the death of Melton, the same as Ruiz minus the CCP aggravator. So the trial court found 3 aggravating factors in the death of Melton, and then the same as Ruiz minus the. So they found 4 in Ruiz, and I think they only needed to find 2, right? 2 aggravators or 1? Is it 1? But they found 4 and 3, so 7 basically altogether. Really, crazy, dude. Yeah, atrocious, heinous. But what? Oh, didn't the C doesn't is the act part? You're right. I was thinking the C had. I was thinking there was one more thing though. A CV. I remember the heinous and atrocious, but are you sure there wasn't one more? Why was I thinking there's a third thing that they named though for the hack? What page are we? 101. Let me see what I'm thinking of. Because it's going to drive me nuts if I don't look. Hold on. Give me 1 second. You could probably just Google it instead. Cruel. That was, C did stand for it. Heinous, atrocious, and cruel. They each stand for something. Yep, hack. Heinous, atrocious, cruel. I knew it. See, I'm not crazy after all. My memory's not too bad. It's just sometimes I have moments, you know. Okay, so let's go back to 101. All right. So, let me zoom in here. Whoa. So, really well, the capital felony. The trial court gave great weight to each of these factors, and the CCP aggravator and the prior violent felony aggravator are 2 of the 3 of the weightiest aggravating circumstances. On the other hand, the court first found that no statutory mitigating circumstances were established. And that out of the 13 non-statutory mitigating factors argued by Wade at sentencing, the court found that 10 were established. 13, they found 10. Okay. But 6 were given little weight and the other 4 some weight. Given that great weight was given to 2 of the weightiest aggravators, CCP and a prior violent felony aggravator, and Rez's murder, and the mitigation is minor, 6 out of 10 given little weight, the others given some weight. There's no reasonable possibility that even if this court finds the hack aggravator should not have been counted, the appellant would have received a life sentence in charge of her murder. Wait. The appellant would have received, okay, wait, there should not have been counted. Even if the court finds that the hack aggravator should not have been counted, the appellant would have received a life sentence in charge of her murder. Any error present was harmless beyond a reasonable doubt, considering the substantial aggravation and negligible mitigation. Similarly, although the jury did not find the CCP aggravator applicable to Melton's death due to the finding of prior violent felony and the felony probation aggravators, along with the absence of any serious mitigation, there exists no reasonable possibility of appellant having received a life sentence in Melton's murder. Given the other weighty aggravators found in this case, even if the CCP aggravator were invalid, there's no reasonable possibility that an absence of this one aggravator would have resulted in any different sentence. An error in finding the existence of CCP was harmless because Hall was significant and weighty aggravation beyond the invalidated CCP aggravator. Okay. And then issue 5, appellant cannot demonstrate that the cold, calculated, and premeditated. So remember, the CCP is cold, calculated, and premeditated aggravator, and its corresponding jury instruction is unconstitutional, either on its face or as applied to him. Appellant Wade also argues that the CCP aggravator and its corresponding jury instructions are unconstitutional. Both on their face and as applied to him. His entire argument consists of quoting verbatim the 4 paragraphs of his memorandum of law submitted to the trial court with his motion, in which argued generally that and its accompanying jury instruction violate the Constitution principles of substantive due process and equal protection that require that a provision of law be rationally related to its purpose, is applied in such an inconsistent manner that it violates the Constitution, that the without any pretense of moral or legal justification language is vague and incoherent, unrelated to the first part of the aggravated circumstances, incapable of narrowing construction, and has not been consistently or narrowly construed. And the standard instruction invites arbitrary and uneven application because it fails to provide the jury the guidance it requires. Appellant, however, waived this argument by failing to properly brief the claim, but even if he had not waived it, the claim would fail because he was failed to demonstrate that the CCP aggravator and his jury instruction are unconstitutional. Okay. Yeah, dude. What do you guys think so far? I'm going to skip some of this. It's going to go, this is going to go through about like, even if this, but this, the same kind of argument layout. So, yeah, I mean, there's too many. It wasn't just like he was found up one. There was too many of the aggravating and mitigating, or hold on. Aggravating, that's what, okay. Let's skip on down. Okay, so this is interesting. The court has enunciated a 4-part test for the application of the CCP aggravator. 1, the killing must have been the product of a cool and calm reflection and not an act of prompted not an act prompted by emotional frenzy, panic, or a fit of rage. Two, the defendant must have had careful plan or prearranged design to commit before the fatal incident calculated. So remember, he got this one for, wait, Diane, right? The CCP, yeah. The defendant must have exhibited heightened premeditation. There must have been no pretense of moral or legal justification. Because the premeditated thing, because like he admitted, and we know like he purposely was finding somebody to pick up to do that. Now with Christine, he went out and like hung out. So you know what I'm saying? So I could see how it was easier to prove that the CCP on the Diane more than Christine. Do you guys see that? Okay, so careful plan or prearranged design to commit murder before the fatal incident. The defendant must exhibited heightened premeditation. There must have been no pretense of moral or legal justification. Okay, so where are we at? Additionally, the court has clarified that a pretense or legal or moral justification is any colorable claim based at least partly on uncontroverted and believable factual evidence or testimony that, before its incompleteness, would constitute an excuse, justification, or defense as to the homicide. Finally, the court has explained that when the defendant had ample opportunity to leave, but instead chooses to kill the victim, there's sufficient evidence of CCP. We have held the CCP exists, whereas here, a defendant has ample opportunity to leave, but instead decides to murder the victim. The jury correctly found that this aggravating factor applies to appellant in the murder of Diane. According to the record, Wade returned to Cape Coral after killing Christine and attempting to murder Mila. He drove around Cape Coral and decided that because he had already murdered one woman, he may as well murder another. He lured Diane into his car by pretending to need direction, using the charm and his good looks. He bragged to officers he used so well to manipulate women, knowing even then that he was not going to let her go and was going to kill her. He then attempted to strangle her to death in the car. When she regained consciousness several times, he repeatedly strangled her again. He then drove to a lot to dispose of her body, only to discover that she was still alive. Finally, he killed her by pushing her out of the car and driving over her body at least one time, but according to him, multiple times. Nor was there any evidence suggesting that Ruiz's murder was committed with any pretense of moral or legal justification. Rather, the trial court correctly concluded that the murder was committed on a whim. Wade killed Diane Ruiz coldly and methodically. After first choking Christine, he then determined that he desired to engage in the same behavior against Ruiz. He had ample time to consider the second murder and consciously decided to continue. After Ruiz came back to life several times. It's crazy. Harmless error. Even if the court concludes that the trial court's finding of CCP was made in error, such an error would be harmless. When the court strikes an aggravating factor on appeal, the harmless error test is applied to determine whether there is no reasonable possibility that the error affected the sentence. Striking aggravator necessitates a harmless error analysis. The trial court found 4 aggravating factors in the death of Ruiz, including CCP, the capital felony was committed by a person. Naming all those again. I'm not going to name them again. We already named them how many times, but all 4, and then 3 for Christine. Okay. So it says the trial court gave great weight to each of these factors, and the hack aggravator and the prior violent felony aggravator are 2 of the 3 of the weightiest aggravating circumstances. On the other hand, the court found that no statutory mitigating circumstances were established. Also, out of the 13 non-statutory mitigating factors argued by appellant at sentencing, the court found that 10 were established, but 6 were given little weight and the others some weight. Given that great weight was given to 2 of the weightiest aggravators and the prior violent felony aggravators, and the mitigation is minor, 6 out of 10, little weight, the others given some weight. And I just realized I only had a couple hours of sleep. I was wondering why I'm like feeling like extremely tired right now. Like I didn't sleep, and I did, and I remember I had to get up early for an appointment, and I went to bed way late because my grandma got up, and I'm a night shower, so I showered at night, and then I get out, and my grandma, she's got all the lights on. I hear this pounding. I don't know what she's opening drawers, and oh my Lord. So then by the time I lay down, I had to get up at like 7:30 for an appointment. So I feel like I probably got, when you have to get up, and I was kind of nervous for the appointment. So it was like I couldn't really even sleep. So I may have got like an hour. I just realized that I didn't really get any sleep basically. Anyway, sorry. Let's get back. Given that great weight was given 2 of the weightiest aggravators, the mitigation is minor, 6 out of 10. There is no reasonable possibility that even if this court finds the CCP aggravator should not have been counted, that the appellant would have received a life sentence, blah, blah, saying the same stuff. Okay. Failed to demonstrate that admitting victim impact testimony rendered his death sentence unconstitutional. Oh, wait. Admitting victim impact. Okay. Oh, it says, so on the Wyndham State, in his final claim, appellant contends Florida statutes is unconstitutional on its face, and that any evidence admitted pursuant to this law renders his death sentence unconstitutional under the 5th, 6th, 8th, and 14th Amendments. He acknowledged the court's decision in Wyndham versus State, in which found the use of victim impact evidence to be constitutional, but he argues that those cases were wrongly decided, and that evolving standards of decency warrant the revisitation and reversal of those cases. Appellant, however, is mistaken in concluding that this evidence is inadmissible and waived this argument by failing to properly brief the issue. So he's saying the victim impact statement, is that what he's trying to say? Is unconstitutional, or admitting the victim impact testimony. Okay. He argues that those cases were wrongly decided, involving standards, decency, warrant the revisitation, reversal of those cases. Okay. Appellant, however, is mistaken in concluding that this evidence is inadmissible and waived his argument by failing to properly brief the issue. Appellant waived this claim by merely referring to his argument below without further elucidation. Wade, appellant, fails to provide proper argument regarding this claim. His entire argument consists of quoting his motion filled in the trial court, adding the 2 sentences. Okay. In the instant case, the state presented impact evidence during the penalty phase, blah, blah, blah. Same stuff, basically. This comment is the entirety of new argument. Appellant makes in his claim, it is nothing more than a conclusion preceded by quotation of his written motion. All right, let me skip through this. Oh, that went fast. Willie. Oh, guys, real quick before I forget. So I have I just started a new Patreon. I was allowed to 2 months after mine got taken down. You're allowed to open one up. You just have to get approved again. But I did it under a different name because I'm just gonna keep it separate anyway. For this whole time, I could have had a Patreon, and I looked into it, and it's like, yeah. Anyway, so it's in review right now. So once it gets published, because K Court gave me the great idea. Any of you guys here that were following me for, if you remember when I did the Paul Ferguson calls, so there's a few, 8, there's 8, and there might be more, but for sure 8 calls. There are 8, like at least 15 minutes or more calls that I couldn't release. Because like, like phone calls from prison, those type of calls that really aren't YouTube appropriate, that I'm going to put on my Patreon, but I have to wait for it to get published or whatever. But I called it Peeping Ears because that's what my merch and my logo, member, that I had created, because it came from that case. Really, if you guys followed that case, you know exactly how it came about, the peeping ear thing. But I felt like it kind of generalized into like my channel, because like peeping ears, like type like, oh, we're always listening, and you know what I'm saying, type like sleuthing, listening with the I don't know, I thought it fit. But not only does it fit, so it's not just supposedly specific to like Paul in that case, because it fits generally. Like I like the idea, the peeping ears, but it was just kind of a funny joke because he called us peeping. He literally called us, my channel and our viewers, he called us peeping ears. So that's where that came from. Because I don't know if you guys go back and listen to my Paul calls, if you guys haven't followed that case. So interesting, those calls. They talk about me and my channel a lot. He was aware of it, and they talked about it a lot. He hated it because I was exposing the cause, but he said like, "Oh, the zavgirl and her peeping ears." Like everybody listening. So I just thought it was funny. Anyway, so that's what I named my Patreon, Peeping Ears. I just wanted to tell you guys before, because I was afraid it came to my head, and I was afraid I was going to end it and forget. When it's published, I'll let you know. I'll put it like a post. I don't have any calls up on there yet. I have to wait till they get reviewed. I want to tell you guys, and then I'll put the calls. So I don't know, I think it could be good, because I mean, if K Court's like, yeah, I'd be interested, there'd probably be people interested in those. So wait, his transfer documents? What are you talking about? I don't know what you're talking about. Okay, let me finish this here. Tends the result of the decision. Wrongly decided, argues that the victim impact testimony could lead to sentencing based on non-aggravating factors. This is basically the same stuff. I'm kind of getting burnt out saying the same. If you're talking about weight, a lot of that's going to be like, if it's medical stuff, a lot of it might be on the HIPAA anyway. So if that's what you're talking about, but yeah. I'm trying, but I don't know if so. I mean, that could be, that falls under HIPAA. We might not even be able to do it. Oh wait, hold on. Oh, here's some stuff about the case. Shoot. Statement of sufficiency of evidence. This could be the good ending here. All right, yeah, we'll finish it off with this because this is specific about the case. Okay. The court has a mandatory obligation to independently review the evidence in every death sentence case to determine whether competent, substantial evidence supports the first-degree murder convictions. Competent, substantial evidence supported conviction of both premeditated and felony murder. Determining legal sufficiency of the evidence to support a criminal conviction requires this court to view the evidence in the light most favorable to the state. Ding. Wait, I forget. What is that for again? My ring, maybe? Ding. Okay. So determining the legal sufficiency of the evidence to support the criminal conviction requires this court to view the evidence in the light most favorable to the state. It asks whether a rational trier of fact could have found the existence of elements of the crime beyond a reasonable doubt. In this case, resolving in favor of the verdict all reasonable inferences one can draw from evidence. There is substantial competent evidence from which a jury could properly conclude that Wade committed the first-degree murders of both Christine Melton and Diane Ruiz. Wade confessed to no less than 3 individuals that he murdered multiple people, including specifically admitting to law enforcement that he murdered both Melton and Ruiz. There exists a strong circumstantial evidence corroborating his confessions and DNA evidence to support his corroboration. Melton's close friend Johnson testified that the night before the murder, she and Melton left around 10 p.m. to go to the Buddha, a bar in Fort Myers, and that they met Wade, who introduced himself as JR, and another man, Jason. When the bar closed, Jason, Christine, Johnson, which is Stephanie, I think her name was, and Wade decided to go to Shepard's house. When Wade, Christine, Johnson left Shepard's home in the early morning hours, they called an Uber because Wade was unable to drive stick shift, and the car they took, where is that? And the car they took there, Mila's car, is a stick shift. Shepard drove to his house. So Jason Shepard drove to his house. Christine, and, Stephanie, and Wade then headed to Christine's residence in Cape Coral. Later in the morning, Stephanie left because she needed to drop off her child at school and then go back to work. When Stephanie left, Christine was left alone at her home with Wade. It was the last time she was seen alive. Later that day, when Wade arrived at Mila's business, Mila's Spa, he was driving Christine's black Nissan Versa. After he beat Mila and attempted to kill her, Wade got back in the black Nissan Versa and fled. Wade then headed back to Cape Coral. He drove into a neighborhood near Hector Cafarata Elementary School. There he encountered Diane, who worked as a bartender at the Moose Lodge. Because she did not live very far away from work, she always walked to work. According to law enforcement, Wade informed them that Diane willingly got in Christine's car that he was driving. When Diane's body was later recovered, she was found with a broken nose, a broken hyoid bone, and a thyroid cartilage. Also, she suffered multiple rib fractures front and back, apparently from Wade repeatedly driving over her. He confessed to law enforcement that he initially believed that he had choked her to death, but that she survived and regained consciousness. So he threw her out of the car and repeatedly drove back and forth over her and tried to make her look like spaghetti. According to the medical examiner, Diane had been strangled. She died from blunt force trauma resulting from multiple rib fractures. The medical examiner testified that multiple rib fractures are likely to occur when one drives over a body repeatedly. There was a neighbor who lived behind where Ruiz's body was dumped. The morning of her murder, he was having breakfast with his wife and saw the car in a nearby lot repeatedly driving backwards and forwards before leaving that location. He did not think anything of it at the time, but when he saw the crime scene tape the next on the lot next door, he realized that it was the one. That it was the one in the same car. When the vehicle was later recovered, bloodstains were found in the vehicle. Um, and DNA testing of the blood determined it to be Diane's. Jacob, it's supposed to be Josh. Typo, they do have typos in these. So Josh from Mateo's Graphics testified that Wade showed up at Josh's office with no shoes, no shirt, blood on him, and frantically seeking Josh's help getting out. Wade informed him that appellant killed some people, Wade informed him that he killed some people, basically. Josh secretly called the Cape Coral Police Department. They arrived at Mateo's Graphics and searched the building and the exterior area around it. But Wade was nowhere to be found. During their search, they came across Melton's Nissan Versa, which Wade drove there. Officers and Salone testified that they looked inside and saw bloodstains. They also discovered 2 phones in that car. One which they later discovered belonged to Christine, and one which they later discovered belonged to Diane. Phone records show that both Diane's number and Christine's number show up on Mila's phone and its records. Wade called Mila several times the day of the murders, even though he left his cell phone at Jason's home the night before. The police did a record check on the car's owner, and they discovered that the car belonged to Christine. At the time, they were unaware of her death. Later, when they entered her home, they discovered her dead body. She was wrapped in sheets. Her face was black and blue. Her nails were broken, and there were marks around her neck. The medical examiner testified that she was strangled to death. Also, her black Nissan Versa, an automatic, was gone. The DNA on the shirts, leggings, the curtain rod, and the ties used to bind up Melton tested positive for Wade's DNA. Wade's biological father, Stephen, testified that Wade called him stating, "I need to get out of town. I need your help. Send me an Uber." But when he started describing that he committed murder, he described it in such a way that his father felt Wade was bragging about it. That Wade was bragging about committing the murders, as if he wanted his dad to feel the excitement he did. Eventually, his father obtained the address where Wade was hiding, telling Wade that he was going to send him an Uber, provided to the police, who located him and arrested him. Later, when Wade was questioned by law enforcement why he killed Christine, he stated, "I just wanted to do it." And when asked about Diane, he responded, "F it, kill her. I got one down. I got one down." In his confession, Wade not only admitted to having committed the killings, but also to the manner in which they were committed, which matches the medical examiner's testimony regarding their manners of death. The evidence establishes that competent, substantial proof of Wade's guilt exists and is sufficient to demonstrate that a rational jury could have found him guilty of both Christine and Diane's murders as charged. Wherefore, the state respectfully requires that this court affirm the judgment and sentence in this case. Respectfully, James Othmeyer, Attorney General of Florida. And then you got Rick as Assistant Attorney General, Office of the Attorney General. Yep. So we'll see what happens. But like somebody was saying in chat, I mean, this could take a year before, and then you got all the other death penalty appeals that he'll be doing. Those, what'd they say, 10, 20 years those could take? But this first one, I feel like this is, I don't know, maybe. I don't know how long this one would take. I don't know what I was going to say. I feel like I wanted to tell you something else. Would you guys really be interested in like, The Taylorship business just call logs of who she called since they won't release the calls. I was working on like a spreadsheet of because they don't give you names, you gotta look up all the numbers. Um, and also I still have Erica's calls to go through. Um, and if you haven't seen oh my god, yeah, I'm tired. I can't think right now. Oh, Rosemary's part 3, which was just basically an hour of all calls. I have that out. And instead, you know how I was doing them where I did a mix of like the messages and phone calls together. And then I just wanted to do the calls by himself. So, people that just wanted the calls. Well, I don't know what to do because the third part is just all calls. So I wanted to make sure if people were trying to listen in order, they saw, part 1 text messages and calls, part 2 text messages and calls. So I wanted the part 3 to be like the text message and calls, even though it's all calls, but just so they know the order. But so since I did that, I don't think, I mean, that'd be stupid to release just the calls because it would be the same thing then. So I probably won't. But you know what I was thinking? Maybe I could actually do a live listening to them and then because then I could like give my thoughts on him. I'm listening, and then maybe I can mix that with the documents, the child support documents, and mix it with that. I don't know. Let me say hi to some of you guys here. Hey, CB, thank you again for letting me know that these were out. Hey, Native Queen, LeBron. Yeah. Hey, Kayla. Casey. Shay. Cicely, Kim. I know it's horrible. He's just so sick. I just can't believe. I mean, I don't know that there's still some people supporting him. It's just, I mean, just the evilness of what. Oh, and just hearing him, on the phone calls, like it's like he hasn't changed. He's still like a really bad human that's like manipulating women, like trying to act like all like he cares about him, and then he doesn't. Oh, really? Hey, LeBron. My insane world. Hello, my friend. Hello, Lauren C. Who else we got up in here? Marnie. Hello. Hey, girl. Hello. Hot Mess Express. I like that name. Hot Mess Express. Kim. Ahuva. Yeah, so then I still have that, and I still have the Steve McDaniels. I got to start on that. I got to finish the Ezra stuff too. I got so much stuff. I just have to finish the Ezra, those interviews. I should just put them out and put a picture up and there, do the audio. I was, maybe I'll just do it. God, I wish I wouldn't have waited so long in between when I started doing the Ezra things, because now I think it's already been like over a month since my last Ezra release. Anyway. Oh, that's another thing, guys, real quick. Jocelyn, I don't know if you're listening. I know I'm sorry about this weekend. I didn't do the open panel. So I watched some of the Night in Idaho. I haven't finished yet. So in the I have my speaker shower. So part 1 I listened to while I was in the shower, but I might want to rewatch it because I couldn't see it. I could just hear it. And then part 2 I watched half of it. Is there only 2 parts? But you guys, I want to do like a because I have some thoughts on that. So I want to do an open panel to talk about that. It's A Night in Idaho. It's on Amazon Prime. I don't know if it's 2 or how many episodes there are. I'll get them done, in a couple days, and then I'll do open panel, and then we could talk about it. What do you guys think? It's good, man. This is the best one out of any of the documentaries I've seen on it, it's the best one because it really like I feel like focuses on the victims and the victims' families, and it's just really heartbreaking and interesting and just like wow, like to hear them recount like when it all happened, what they were feeling and like how, it's just like, whoa. It just kind of like I feel like it makes me like puts me there and almost makes you like feel obviously, I mean, not gonna feel what they feel, but it's like almost I don't know. It's hard. It's very sad. And it's just like, oh my gosh. Like, wow. It's good. And just like Hunter and like him, and like what their thoughts were and like the kids that the students and what they were thinking as it was going on, you know what I'm saying? Like they're sharing like their thought processes of like as it was all unfolding and stuff. It's just crazy. Now, so far, I haven't watched it all, but so far, is good then Gonzalez, did they not take part in that documentary? Because they're not in it yet, I feel like. Unless if they're in part one, I didn't recognize their voice, but I don't think they are. It's good though. So yeah, Jocelyn, are you here? I know for sure, at least I know you'll come up on panel because why do I feel like I might have a panel and nobody might even come up? Nobody wants to come up, but I know Jocelyn would. So I was supposed to do it this weekend though, so at least I'll probably have one person. But come on, will other people come up and just share their ideas on like what you thought about what you thought? Like we'll do it. What's today? Tuesday. Um, I don't know. When do you want to do it, guys? I still have to finish it, but I didn't forget about it. I just had a kind of weekend that was just, I don't know, like a weekend where I was worrying, but it was all good. The thing I was worrying about ended up being all good. So just like health stuff, I get like panic attacks and I had my appointment today and everything's good. So it was like I just kind of like let myself spiral and worry, thinking the worst. And then it ended up being the best basically. So, and like when I get like that, it's like I can't, it's hard for me to like think of anything else but that. You know what I'm saying? So it was just like I was just not in the mood to go on a live, especially do like an open panel, But yeah, really? Why, Casey? I feel like out of all the ones I've watched, this one is the most heartwarming and it's most like where I feel like like it portrays and helps like paint like who the victims were. Like I feel like it gave me the best so far, like knowledge of like kind of understanding who they are. That's a shame that they don't want to be a part of that because this is the why? I don't understand. Huh? I didn't know that. I think it's really good. Um, I really like Ethan's family. They seem really like loving and like and also Maddie, they seem so sweet. Her like would be her stepdad and her mom. Now I didn't see her dad yet, but like I said, when I was in the shower, I could just hear the voices, but I don't remember hearing like any was her dad in it or not. I know her stepdad. And then I don't know, just like and like having the students and just everybody explaining like how they were and who they were, and I don't know. It's really good so far. Um, I definitely would recommend it. Like I said, it's the best one that I've seen so far. Oh, hey, Dolly. Proud to be British. I try to watch you live, but it's 3:40 a.m. here in the UK, but love your oh, thank you. Okay, so tell me in chat, is anybody here in chat that would want to come up on panel to talk about the Idaho case? I know, right, Shay? I don't get it. Ooh, really? Oh, I'm sorry. Gosh, hell. Oh, thanks, LTD 805. Does that stand for like limited 805? Terminus. Terminus? No. Terminal. Casey. Casey, were you the only mod here? Well, I know K-Court stopped in for a little bit, but besides that, were you the only one here this whole time? Hey, Jim. Hey, allegedly with Annie. White Wolfie. White Wolfie. Yeah, right? Yeah. Yep. I do. It's a lot. Hey, Lauren. I feel like, is there anything else I need to tell you? I don't think. I don't think. Yeah, and I still want to do those autopsy reports of some of those ones. You know what? Okay, I have a question. Like, let's say, like, some of them, if I don't have time to take notes on all of them, like, did you guys like going through it in the moment and like looking up stuff? I don't know. I know it annoys some people, but those will be interesting too. Like I said, like the Kurt Cobain, Kim Porter, Brittany Murphy. I still have to do those too. Yeah. Gotta get her done. Oh, there you are, Jocelyn. Yes. Have you watched the Idaho thing already? And is there two-part? Hold on, let me see. I don't even know if there's two or because like I said, I'm on the second one, but I don't know. Is there one after that? Is it a two or a three-parter? Let me see real quick. Okay, Lauren, cool. Angie, maybe I'll have some and then some save, I'll look up maybe some of it real quick and then have some, or I don't like feel like I have to have so much. You know what I'm saying? Where some I'll look up with you guys. Oh, Jocelyn, that's what I want to do the open panel on. The one night in Idaho, watching it. It's on Amazon Prime and talking about it because I've been really wanting to do an open panel on the Idaho case. I think it'd be really interesting because I want to just hear everybody's thoughts. But that new documentary came out on the 11th, and I said like I was supposed to do it this weekend where everybody watched it this weekend and then we talked about it. But since I haven't watched it yet all either, hold on, let me see how many parts it is. It's called One Night in Idaho. It's on Amazon Prime, and hold on, let me see how many parts it is. It's really good. Do you know that case, Jocelyn? Oh, okay. No, not the one on Peacock. But no, you watch that too. But the one that I want for sure to watch, you guys to watch, is the One Night in Idaho. It's called. Hold on one second. Let me get it. Hey, I downloaded hold on a second. The actual Prime app. Where did I put it? There it is. Okay. Because I usually would go through my Prime videos through my Amazon app, but they actually have a Prime, just this only the videos app. Because I used to just go to my Amazon and then you could go to Prime Video through your Amazon. But I just realized they actually have one that's just Prime Video. So that's what I downloaded. But either way, you could watch it with either way. Okay, let me find it. Where is it? Should pop up since I was watching it. Why am I making that noise? I don't know. I'm silly. It's just like One Night in Idaho or something. I don't know why it's not popping up. I would have thought it would have, though. It popped up when I downloaded it the first time. Okay. One Night in Idaho. Well, let me see how many. Oh, there's a bunch. Whoa, no, cool. There's 5, guys. 5 episodes. Good, because it's so good. So you're saying Consolves they're not in it? That's a shame because it's so good. I was anxious to hear like from all the families. That would have been really good to have them all there. But I don't understand why. Because they're very vocal and they go on like the news channels all the time. So why wouldn't they wonder why? Huh. Does you guys have you heard of a reason or no? I'm curious. Why isn't this working? That makes me very curious of like, is there a reason? Huh. Wow. Okay. Anybody know why? Oh shoot. Igor! I'm trying to pick something up with my foot. Okay. Oh. I know that's really cool. There's 5. Now I'm really excited to get because I was thinking there was only maybe 2, but I was hoping there was more. All right, guys. So how many have watched? Okay, so Jocelyn, get on it since you're gonna come up, watch them. So maybe in a few days, because I really want to talk about it. K-Core, have you seen it yet? Do you have Amazon Prime? You have to. They're so good so far. AGM, have you? Are you guys into the Idaho case big? Well, I know you are. You guys watch it. Or you were following it, yeah. Crystal, what's up? And okay, I'm waiting for my Patreon to get reviewed and accepted. And then um I have it as a command, but don't use it yet because it's linking to like the member because you know how like you're the creator or a member, it's not linking to my creator one yet. So I hope it changes when it publishes. So I'll do the Paul cause. Angie, what's up? It's just like watching it and what he took from those families, Koberger, it just makes me like, first of all, so sad for the families. And so like it puts you like right, like feeling like where so much of where they're coming from. And then just like so freaking, oh, like angry with him for doing that, you know? And like how it affected them, like how like their feeling of safety, like all the families and the students, like they didn't have that. Like they couldn't even like go to bed at night without like freaking out thinking like, oh my God, like and then when the law enforcement said it was a targeted attack, which is bullcrap, like targeted, but yet then don't offer any kind of like explanation. So like the families are thinking, okay, like is it somebody we know targeted? Like, are they going to come after us or friend, and then the friends group, or like, or they could come after us? I think it was Ethan's brothers. Like I had to I checked the locks like 3 times. Like I kept checking to make sure the doors were locked. Like it took away their sense of like safety. They couldn't even feel safe in their own house because of what Brian did. Jerk Koberger, like evil, you know? And I don't know. It's horrible. It just like you could just they just explain it so well. Like you could just kind of like really feel and like understand what they all went through after that. It's crazy. Um, yeah, K girl. Um, Oh, I see, Jocelyn. Yeah, maybe. Maybe. Huh. Oh, yay. Got it. Welcome, mod key cord, new mod, new mod. My arm's like itching. I can't stop itching it for some reason. It's not really. It's like weird. I don't know how to explain it. It's not like it itches like I have like a bite, but it's just, I don't know. Oh, I'm silly. Um, all right, you guys. Mine angelic thanks. Or are you talking about somebody else's? But keen to watch if so. What do you guys have? Australia? What case, Lauren? Yeah, Kayla, where are you from? Are you from the area? I mean, even if not, I can understand why you'd want to keep it. But are you from Idaho or anywhere near where it happened? All right, y'all. I better go. I better go. Have a good one, guys. And welcome, K Court. Welcome to the mod family. Family. Um, did Soul didn't stop. But wait, did hold on, let me make sure I was texting with Soul, but I was like, did I just assume that she knew I was going live and didn't tell her? I might have. Oh my gosh. Why do I just assume that she would see it? I don't think I ever did say. And I was thinking that she understood that I was about to go live. I never even said it. Oh my god. Oops. Oh my god. Anyway, guys, all right, I'm gonna go. Have a good one. Watch the Idaho, because even if you don't want to come up on panel, I want to discuss it. So even if I could discuss it in chat, so even if like nobody does come up, it wouldn't be that bad. I mean, I wouldn't. Let me word this right. I would still do it. I would still have a lot to talk about. I would just talk to you guys in the chat and then see what you guys are saying back in the chat. You know what I'm saying? But if anybody wants to join, you can too. So, um, Central Florida. Okay. Down under? Say down under. Wait, did I say it already? Did I say it? Or you just tell me to say it? Or was it like something I said and you want me to say it again? No, I didn't say it down under. They're like down under? I don't know. All right, guys, I'm gonna go. I got my air off so I can pop that back on. Actually, it wasn't too bad, which is weird. I mean, I was getting a little hot, but it was like 90 out today. That's crazy that it wasn't hotter than it was. Um, Yay! Oh, I'm so happy to have you. What is that picture? What is that, Jocelyn? I can't tell what that is. It's almost like it's have a part of me. I mean, initially, I think it looks like a face, but not like a human face with big glasses and a microphone. This is what I'm seeing, like a mic. There's a big nose, glasses, but it's not human. But I'm probably looking at it weird. And once I realize, if you tell me what it is, once I realize what it is, it's probably gonna look something so different. You know how sometimes you could look at something and you could see something and then you know what it is then after, like if somebody tells you what it is, you're like, oh my God. Like, how didn't I see that? It looks totally different. I don't know. What do you guys think it is? Australia flag? I'm not even seeing a flag in there. Wait, I do not even see a flag. Hold on. I gotta adjust my eyes. I gotta figure this out. You're saying your picture is an Australian flag? Are you guys seeing it? I can't get it. Why am I not able to see it? Hold on. No. Oh, yeah, your icon. What did you think I was talking about? I was like, wait, I cannot adjust my eyes to get it. Okay, what is it? Anybody guess? Yeah, that's what I saw too. It's like somebody, it's like not a human face, so it could be wearing a mask. Yeah. And like I said, it looks like right here's the nose, there's glasses, but it's either, yeah, I guess either a mask or somebody that's not human. But it almost looks like there's a microphone right here. Oh, do you have a microphone? A gas mask. Well, I was basically seeing it right. A face, a face. I said, oh, it didn't look like a human face because it was a mask on it with glasses. Okay, so yeah, but what's that like right there? Down. Oh, I see. Okay, so there's no microphone then, obviously, right? Wow. Let's look at somebody else's. Well, everybody else now I'm looking at is just their face. Okay, hold on. Okay, Court, you have a horse. Is yours a horse, right? Is that a horse? Because you can only see a part of what you're touching. Are you like petting a horse or no? I can't tell. But that's what my eyes tell me. Just like my brain just goes there, even though that part you really can't see very good. But my brain just thinks it's a horse. Is it? Oh, okay. J Lo. Oh, I like that for a horse. J Lo. Oh, your doggy, Laura. Oh, the cute little baby. I love doggies so much. I should go get Zeke and have him sleep with me. Skywalker, what is yours? I can't tell. Looks like maybe there's a face that you're blocking with the emoji, but I can't tell. Casey, yours is just your face. Angie's is a yard, farm, or something. Let's see if anybody else is like something original, not original, but like different, like where it's hard to tell what it is. Let's see. What's this? Angelic. Yours is a shell beach, something at the beach. Turtle. Turtle? Is that a turtle? You guys don't realize it's so small. So like, well, you guys do realize. So it's hard to see because it's small. That's the whole trick. So that's what makes it fun trying to guess. But Angelic, I think yours is a turtle. I feel pretty confident on that. LTD, yours just says hope, faith. See that little YouTube sign is blocking some of that other one. That's why I can't tell for sure what the other one says. Faith, I think. Anton, yours is the actor from I forget his name, but he plays on that one movie that's really good. I can't think of the movie that I'm thinking of too. I keep like scrolling up and then it's the same people repeating. So I can't find like a new picture. It's the same people in chat over and over. So there's not, let me see. Well, I'm scrolling up. Maybe I should scroll down and there'll be something new. Oh, Santa Claus. Okay, girl. Okay, girl. You're just a little heart. Okay. Oh, man. Yes. Okay. Well, I don't see any other new ones, guys. Mari, yours is your face. Okay. That's fun, though. Come on, somebody say hi that's got a unique profile thing. Or just say hi if you haven't said hi yet, so we can say hi to you. K-Court, yes. Whenever my Patreon gets approved, did you hear me saying how it's in review right now? So I have to wait. So then it wait till it gets approved, and then I could publish something. So I'm just waiting for them to approve it. But as soon as they do, all right. Yeah, so when I was texting you earlier, I was under the impression that, like, I don't know why, like, that you knew, like, as I was talking, that you were like, I don't know why I always assume, like, for instance, even if I like see somebody in chat, like, I assume, like, oh, they see, like, that I'm saying hi, or like that, yeah, that I see him, or but yeah, when I was texting you, I just thought you knew. And I just realized when I said, oh, Soul's in here, then I went through our messages and like, you know what? Maybe she didn't know. But I was just assuming that you knew as I was texting that I was getting ready for those lives. Sorry. I need to just like stop doing that. Like you're not. You can't. I don't know what I'm talking about. I'm in one of those moods where it's just like um yeah, Step Brothers. One of my friends got me it for Christmas. Isn't it funny? This person does it. Like you just send them a picture of you and your dog, and then they'll make the Step Brothers thing. So one of my friends got it for Christmas. All right, guys, I gotta go. I'm gonna go. I gotta move my legs around. Thanks, guys. See you, baby, tomorrow.